filed their written statement. So it was appearing as an undefended suit. Now, my lord, they have filed an application, my lord, for recalling of the order of the undefended suit and for an extension to file the written statement. Now, my lord, unless and until that application is heard, if they get a chance to file their written by any chance or the other, then perhaps the witness action would.
When it is fixed? Tomorrow?
26th.
26th of
February at 3:45 p.m.
Come tomorrow, we'll see to that. Yes.
But could I mention, my lord, and assign section 34?
Yeah.
Yes, my lord, your lordship had the occasion to consider the section 36 application. Certain orders were passed directing me to deposit. My lord, we went up to the Supreme Court, lost. That's another. Now, my lord, the execution is being proceeded with, but the section 34 is assigned before this court.
The problem is, my lord, as I perceive it, my lord, in the execution case, a section 47 point has been taken. IPA for the West Bengal Industrial Development Corporation.
That one.
Yes, yes.
So, my lord, ultimately the questions will be the same questions because, my lord, your lordship might remember that Amrit Vanaspati gas case, my lord, that was, my lord, the issue. So, my lord, the same issue, my lord, as to whether that will, my lord, stand in the way of the award.
Now, what you want?
Problem
Hearing
is,
of
my
the
lord,
section 34.
I am for the respondent. Problem is, my lord, generally, my lord, one would not, my lord, oppose, my lord, quite naturally, my lord, the listing, my lord, prayer, my lord, made. But 12th July, my lord's order was, my lord, that they should deposit. My lord, then, my lord, it went up, my lord, to the Honorable Supreme Court. They lost, no deposit. And, my lord, the execution, my lord, is also, my lord, languishing. Execution is there. So, my lord, they should really have to deposit. They can't, my lord, have the section 34 heard without, my lord, really, my lord, having the money deposited. My lord,
That's no ground.
Obviously, my lord, that's the intention.
If I don't
That's the
deposit, they
intention.
can proceed with the execution. But that doesn't mean, my lord, section 34.
No, I'm not
cannot
saying,
be
my lord, perhaps, my lord, legally I can't stand in the way, but I'm also bringing this to my lord's attention that in spite of orders of this court and, my lord, the order of the Honorable Supreme Court, no deposit has been made. No deposit has been made.
My lord, executing court if your lordship is so inclined.
No, my lord, we can. This is the main, my lord, this is the main matter. My lord, we can have the execution brought here.
Here's both the matters.
We can have the execution brought here. We can have the execution brought here.
It will be better. This may be heard by the executive.
Whatever your lordship pleases.
My lord, this is the substantial court. My lord, section 36, my lord, has heard. Section 34 also, my lord, has heard. So, my lord, or rather, my lord, it's before my lord. So, my lord, that section 36 has been heard. My lord, we'll have that matter, my lord, brought here. My lord, puts it, my lord, any day, my lord, as to be mentioned, and my lord will come back because I'll.
Let me know Friday, Monday has to be mentioned.
Monday has to be.
Very well. Give the number. Monday, it will take us to be mentioned. Then, if both the party concerned, I will fix the date.
Very well.
Date is completed, no?
I don't think so. I don't think so. But
Okay,
I'll check.
Let him, my lord, come as to be mentioned.
Let
And
the
my
record
lord,
come.
yes.
I'm grateful.
Monday has to be mentioned.
Grateful.
Yes.
My lord, my lord, my video has been disabled, my lord, by the officer. My lord, I'm in very compelling circumstances, my lord. Kindly pardon me today. There's a fixed matter. Item 3, my lord, at 11:30.
Lord, we are mentioning upon notice. I have the notice with me.
Yes.
My lord, item 3 at has been fixed at 11:30, my lord. Today I'm in some difficulty. If your lordship kindly keeps it tomorrow, my lord, or any other convenient date, my lord.
Okay, I will take care of it. And when the matter call, any junior will be there, then I will take care of it. No problem.
Grateful, my lord. But because it's a fixed matter, my lord, I thought I should mention in the morning.
Okay.
And there's one more matter, my lord, item 19. Sorry, my lord. This will also be
19, my lord, I am up here.
Item 19 is also fixed matter.
It is not a fixed matter, my lord, but it will surely be taken up by your lordship's list.
Okay,
if the matter is, please mention.
This your lordship remembers, my lord.
Yes,
That is the matter, my lord.
If the matter is, please mention anybody, then I
My
will.
lord, I am on the other side.
Please.
My lord, the only reason, my lord, your lordship knows, my lord.
Okay, I will fix if the personal difficulty is telling that the lawyer.
Very well, my lord. My lord,
But if a date may be fixed, my lord, Mr. Thakkar was to conclude his submissions. Any day convenient to your lordship, my lord.
Which one?
My lord, item number 19, my lord.
Can be fixed on the 4th.
At the convenience of Mr. Thakkar. My lord, I have no difficulty.
On the 4th, if it commences to your lordship, my lord, Monday is the next commercial court day.
4th March देखो 345 है खाली है 345 कब खाली है
4th, 5th, any date convenient, my lord.
उससे पहले कोई खाली नहीं है.
that
So
is,
it is better let it remain in the
lordships.
That is the
My lord, this is the difficulty, my lord.
let it remain in the list. I am not adjourning the matter. Today I will adjourn. Let it remain in the list.
I understand your lordship's predicament also, my lord. That is why the bar also
Can it be Friday, my lord? Can it be Friday because my learned friends wants to complete my Friday second half if it commences?
Today is the Tuesday. Then Friday automatically it will be in the list. If time permit, it will be taken.
Please. Wait.
Yes, yes.
The extension to file to complete the amendment.
Huh?
So Lordship was kind enough to allow my prayer for extension of time to file amendment. Testamental procedure.
Hmm.
Your Lordship was please kind enough to pass an order
Hmm.
to carry out the amendment within fortnight. That has not been done, Lord.
Hmm.
So I am praying for extension of time to carry out the amendment. Testamental procedure.
When the order was passed,
16th January.
why you not complied with?
I have tried my development department.
Okay, to be mentioned, Mero. Let it become as to be mentioned.
May I have Lordship's leave to mention a matter for drawing up and completion of Lordship's order dated 21st January. This particular.
My lord, this matter pertains to a letter of administration, my lord. In your lordship's order, it has been stated as probate in one place, my lord. I am seeking correction of that.
My lord, may I have my lord's kindly, my lord.
Just
No, no. Last line, my lord.
That is administration.
Yes, my lord. I have marked it.
So and so appearing for the petitioner. Learned counsel appearing for the petition has mentioned the matter for correction in the judgment order dated 22nd January 2025. By an order dated 22nd January 2025, this court has granted letters of administration, but in the page number 2, last but one paragraph, it has been recorded as probate instead of letters of administration. In view of the above, in the order dated 22nd January 2025, page number 2, last but one paragraph, in place of the word probate, that shall be read as letters of administration. This order may be incorporated with the order dated 22nd January. Yes.
May I have your lordship's leave to mention item 6 of your lordship's list? It's fixed at 3 p.m. as an undefended suit. Certain documents, my lord, are exhibited in a proceeding in the Bankshal court. We have applied for certified copies, but they have not come. Original invoices. So, my lord,
For the other side.
it's undefended.
Undefended, yes.
So I was humbly that this may be adjourned today and some other date may be fixed, my lord.
Okay, come at 3:30. I will say 3 p.m. Then.
Very well, my
My lord, may I have my lord's kindly, my lord, to mention a non-commercial suit in this matter, my lord. Upon notice, my learned friend is appearing. My lord, the amended plaint has been served, my lord, though belatedly, my lord. I have already prepared my additional written statement. It was, my lord,
Amended plaint addition. Acha.
my lord, liberty was given, my lord, upon me to file the additional written statement, my lord. Though the amended plaint was served belatedly, my lord, it has been affirmed, but my lord, the department is not taking because I have lapsed the time. So, my lord, my kindly.
When you receive the written
Lord, the amended plaint, Lord, though was affirmed in 22nd of
when
November.
you received.
Lord, I had received it on 18th of December.
Ah.
And Lord, my additional written statement is already ready. I just need to file it, Lord.
18th of December. Why you not file the written statement by this time?
No,
30
Lord,
days is over.
Lord, I was given 3 weeks. In between, there was Lord Christmas vacation, and thereafter the.
Yes.
So no objection.
Sir, no objection. He's saying, sir, no objection. That is why. Your Lordship, may kindly keeps under to be mentioned, my Lord, tomorrow.
To be mentioned, Calcutta.
Tomorrow, my Lord. Extremely grateful.
My lordship, sir, can you please, the matter may be listed on next Monday because my senior is not.
Monday.
Only you're telling that to be mentioned. Only I will extend the
for
time.
extension of my time to file the written
I will
statement.
not pass any further order. He is asking for acceptance of the additional written statement. Let me see the record. Then you are telling that you have no objection. After going through the record, I will pass an order. Your senior is not necessary.
Extremely grateful.
Find leave to mention a matter on the commercial side. This was appearing as item number 12 yesterday. My lord was pleased to fix it on Friday, 28th. My lord, however, the order reflects 28th March. My lord, my interim order is supposed to expire on 28th. I am carrying a copy of the last order where the interim order is expiring on 28th. My lord, kindly keeps it on Friday.
Twenty-fourth. Yes, 28th March.
My interim order is expiring on 28th. my
अरे
lord.
28 February था.
But it was item 12, Mr. Das was appearing, my lord.
नहीं 28 February interim Mr. Das had appeared. ना upload हो गया. So and so appearing for the plaintiff. Plaintiff has mentioned the matter and submit that the matter was listed yesterday, and this court find that the interim order is going to be expired on 28th of February 2025. Accordingly, this court has fixed the matter on 28th of February 2025, but inadvertently in the order dated 24th February 2025, the date has been recorded as 28th of March 2025. Consider the submission made by the counsel for the plaintiff in the order dated 24th of February 2025. In the third paragraph, the date shall be read as 28th February 2025 instead of 28th March 2025. Let the matter appear on 28th of February 2025 instead of 28th of March 2025.
Lordship, may I have your kind leave to mention a matter? This is a suit for eviction on the non-commercial side, and there was a GA application. Lordship had heard that in part, and then it was fixed for further hearing, and interim order was extended till 26 February. But then the monthly list came, and the matter is not appearing. My interim order is expiring tomorrow.
Can mention tomorrow? I will.
Lordship, it's not coming in the list. It can be added in the list tomorrow.
Non-commercial?
Yes, sir.
Listed tomorrow as for
I have
action.
served notice to the other side.
Action.
Masha.
Can I seek your lordships kindly? Your lordship, I seek to mention a matter. This is a matter in your lordship's regular list, non-commercial matter. This is civil suit for money lent, recovery of money lent in advance. Lordship, what had happened by your lordship's last order dated 14th of July, the matter had gone out of list on the ground that the petitioner therein was under incarceration and a general power of attorney was to be executed. Subsequently, your lordship, the petitioner has passed away. Your lordship, the substitution petition has been made and it needs to be heard out, your lordship. Just for inclusion.
What do you want now?
Your lordship, just for upgradation, your lordship.
Upgradation of what?
Of the
Suit.
civil suit. Yes,
Suit
your
was
lordship.
the plenty passed away, then how the suit?
Your lordship, the substitution application, my instruction that the substitution application has been made and the substitution has been carried out by your lordship, by the leave granted by your lordship.
Substitution allowed?
Substitution has been allowed, your lordship.
When? By which order?
Your lordship, in the month of August, your lordship, I'm not carrying a copy of that order. That is my fault, your lordship.
Come tomorrow with the order.
I'll come with the order, your lordship.
Come
With the order wherein your lordship. had
Whatever
given
the order
to
came,
mention.
come with the order, then I will see to
Your lordship, I'm grateful to you.
Yes.
My lord, I am for the plaintiff, my lord. This is a commercial suit. My lord, summon of the suit has been served upon the defendant on 13th of September 2024. And the defendant appeared on 7th of October 2024. My lord, we have obtained the report up to 27 January 25. No written statement has been filed. So,
When
my
the
lord,
writ of summons was served?
13th of September, my lord.
Huh?
13th of September. I have handed over the report, my lord.
13th of September, my lord, has been
13th September 3 p.m. One duplicate copy of the original letter along with the copy of the print was served upon the defendant. Okay. Bata company is not appearing.
appeared, my lord, 7th of October appeared. From the next report, your lordship will find that 7th of October
Copy
appeared.
of the original letter along with the copy of the address. Yes, September it was delivered. Entered appearance on 7th October.
Yes.
They have entered appearance. Till date they have not filed written statement.
Yes. my lord. The
No
report is
written
also there.
statement from the September, October, November. This is January. So when 120th days is over?
11th of January, my lord.
11th January, my lord.
11 January. From?
From my lord.
13th of September, my lord.
So appearing for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff.
On notice I have mentioned.
Plaintiff. Full stop. Counsel for the plaintiff has handed over a service report dated 29/11/2024 issued by the Deputy Sheriff of Calcutta, wherein it reveals that a writ of summons was duly served upon the defendant on 13th September 2024. 13 September 2024 through the bailiff, and on 24 September 2024 through the postal services. Full stop. The plaintiff has also handed over the report issued by the Deputy Registrar Legal dated 5th December 2024, wherein it reveals that the defendant has entered appearance through Victor Moses and Company on 7th of October 2024. Full stop. The defendant has also obtained report from the Deputy Registrar Legal dated 27th of January 2025, wherein it reveals that no written statement was filed. Full stop. Counsel for the plaintiff, relying upon the above mentioned reports, submit that time to file written statement has been is expired, but till date the defendant has not filed written statement. Accordingly, the counsel for the plaintiff prays for fixing the matter as in the list of undefended suit. Full stop. In view of the submission made by the counsel for the plaintiff, consider the reports and the submission made by the counsel for the plaintiff. Let CS Com 673 of 2024 be placed in the list of undefended suit. Full stop. The defendant and the plaintiff is directed to file the judge's brief of document within a period of 2 weeks.
3 weeks, my lord.
Within a period of 3 weeks. Full stop. Affidavit of evidence of the plaintiff's witness be filed within 2 weeks thereafter. Full stop. List the matter. Give the date for witness action. 17th April at 2 p.m. for witness action.
Well, notice has been given to the defendant regarding mentioning matter.
To be mentioned bolan, and the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff after notice to the defendant, but none appears on behalf of the defendant. The reports be kept with the record. Yes.
Wait, please, my lord. I appear for the plaintiff in this matter. Lord, suit for delivery up and cancellation, Lord, of the 4 letters which, my lord, have been written at the dictates of the defendant bank.
Yes.
My lord, suit, my lord, for delivery up and cancellation, and my lord, for specific performance of the OTS, my lord, granted by the defendant bank. My lord, both the parties are within, my lord. Hence, my lord, no leave under clause
How
2.
the OTS will come here?
Yes, my lord. My lord, there, my lord, I am saying, my lord. Your lordship, just to, my lord, I am also seeking leave under 12A. So, my lord, I have to dwell into.
Correct, but you are challenging the OTS.
No, I'm not challenging the OTS. I am, my lord, seeking for delivery up and cancellation of the 4 letters which have been written, my lord, by the plaintiff at the dictates of the bank, my lord. That case I have made out. I'm not, there's also suit for declaration. Now, my lord, the purpose, my lord, behind this, my lord, is your lordship, just to directly take my lord, kindly turns to page 114. There was a, my lord, there was a line of credit given by the Bank of Maharashtra.
Correct.
Lord, which was time and again serviced by the plaintiff, and Lord, payments were regularly made.
Correct.
Then, Lord, in between, Lord, OTS proposals were given, accepted payments made.
OTS, prior to the OTS, there might be a NPA.
Lord, there was a default.
Yes.
Subsequent to the default, Lord, there was an OTS as well.
And section 13(2).
13.2, my lord, thereafter section 7 of the IBC, withdrawn, revived, dismissed, everything, my lord, happened. My lord, the bank had lost at all forum possible. Now, my lord, what is being done? Your lordship may kindly seize, my lord, page 114 first. Or rather, my lord, kindly turns to first page 109. This was the proposal, my lord. After everything has been done, we propose them that we are going to end this financial feud between us at a sum of rupees 56 crores. That was on 27th of December 2024. Your lordship may kindly seize at page 109.
It is your letter.
This is my letter.
You have given
Then, my lord, at 114,
it is your proposal.
it is my proposal.
What was the total sanction?
My lord, the total sanction was, my lord, 90 crores initially. Then, my lord, with interest and all, it, my lord, added up. Then, my lord, we had paid subsequently 50 crores we have already, my lord, discharged.
This is the proposal given by
This
you.
is the last proposal given by me. That was on 27th of December, wherein I had stated that I am ready to close the dispute at 55 crores. Your lordship, then at page 114 is the acceptance of the bank, my lord, where they say that you increase your OTS from 55 to 56 and you pay upfront 1 crore. My lord, this my lord, direction of the bank was duly complied by us. We had paid the 1 crore, my lord, and we had also communicated it to them by way of the another letter that is at page 116, 2nd of January. So, my lord, may kindly seize the letter, my lord. They at page 114, they ask us to deposit 1 crore towards the upfront amount as discussed and agreed. And they ask us to enhance the sum from 55 to 56. 2nd January, my lord, we intimate that we are ready and agreeable to 56 and we have already paid 1
Where
crore.
it is?
Your lordship may kindly seize page 116. Second line, my lord. We says, as advised, we have paid an upfront amount of 1 crore at the time of submitting the proposal. And Lord, third paragraph, last line, we have raised OTS offer from 55 to 56 crores as advised upon by the bank. So, my lord, up to this, my lord, everything was fine. Now, my lord, the bank, after we pay them the money, my lord, then they turn out and this.
So how much amount you have paid?
My lord, I have already paid 1 crore, my lord, in terms of that letter dated
January 2025.
31st December 2024, I have already paid. And my
then?
lord, under the scheme, my lord, it was that I'll pay till December 2025. On
Where
that,
is the scheme? Where is the scheme?
Your lordship, the scheme, my lord, the proposal which was given by us.
Proposal.
Yes, my lord.
1 crore upfront, 8 crore 25. Have you paid 15 crore June, 19 crore census?
So, my lord, now, my lord, the situation is, or my lord, the position between the parties is, my lord, that
With respect
31st
to your
December
letter,
2024
you have increased the
is
OTS
the
offer.
acceptance letter by the bank.
Yes, then
Now, my lord, what is sought to be done? Your lordship may kindly now turns to page 171. Lord, 114 read with page 171, your lordship will find after my lord after my lord directing that you pay this much money in terms of the proposal we pay, now my lord they turn back. Now they say that no, your proposal is rejected.
where it is?
My lord, at page 117, your lordship may kindly sees. They say at the outset contents of letters and such are incorrect. And they say that presently no OTS proposal is pending with the bank. And at page 172, they say that OTS is not acceptable as per bank's policy and guidelines. Submitting OTS proposal is only to delay recovery and legal proceedings initiated by the bank. Please note that there is no OTS is in vogue in the account of Senbo Engineering and no OTS proposal is pending with the bank. And these letters, my lord, I have sought delivery up and cancellation, which starts all the way from page 117 onwards till 170. 5 letters.
Yes, then?
Yes, my lord. So, my lord, at this stage, my lord, I am seeking, my lord, Leave under 12A for two reasons, my lord. Because, my lord, the bank on the basis of this.
How this transaction can be dealt by this court? You go
Lord,
to
this
the
is a
DRT,
suit.
file a
No,
section
no.
17
Lord, there is a
application.
section 7 pending before the NCLT right now. The second section 17. First section 17 was already dismissed. Your lordship may kindly appreciates. My lord, on the basis of these letters, the bank is, my lord, proceeding in section 7 proceeding and, my lord, taking advantage.
So go and take.
So, my lord, my case is, my lord, that, my lord, I have filed a suit for specific performance, my lord. The bank, my lord, cannot, my lord, approbate and reprobate at the same breath.
Go,
My lord, they can give a proposal.
Go
We
before
will.
the DRT, take
My lord,
deposit
proceedings
the
before
amount.
DRT is already pending.
That's why the
There is
court
a
can
section
interfere.
7. There is a section 7, my lord, earlier which was dismissed.
Sorry.
Your lordship, thereafter, my lord, it was, my lord, again dismissed. My lord, they had filed an application for, my lord, revival. Your lordship may kindly considers the urgency, my lord. On the basis of these letters, the bank is taking advantage, my lord.
Sorry, sir.
Taking, my lord, high-handedness. Your lordship may kindly appreciates this, my lord. Banks, my lord.
Alternative remedy is there.
No, my lord, there is no alternative remedy. I am seeking, my lord,
the 17. Go
my lord, there is a section 17 pending. Section
so
7, my lord.
Go file a miscellaneous there.
My lord, section 7 is already pending, my lord, before NCLT. The second section 7, my lord. Now, my lord, bank is taking advantage of these letters, my lord. First, they say that you pay this much money. Then they, my lord, turn their back. Your lordship may kindly appreciates this fact, my lord.
Yes.
My lord, in terms of my lord, letter dated 31st of December 2024, I have duly paid, my lord, 1 crore. Now, my lord, after taking the money, in terms of the proposal, they cannot turn back. Your lordship may kindly appreciates this fact.
Okay.
And my lord, this plaintiff, my lord,
this
your
court
lordship
is
may
not satisfied.
Lord,
What you want to tell, otherwise I will pass it.
your lordship may kindly, my lord, just your lordship may kindly appreciates two facts, my lord. First of all, my lord, this plaintiff.
I am not satisfied.
Your lordship may kindly allows me 2 minutes. 2 minutes, my lord, I shall. The plaintiff, my lord, first of all, my lord, is engaged in, my lord, the airport metro railway. If, my lord, the company is admitted into CIRP, my lord, everything will, my lord, be into chaos.
Go there.
Subsequently,
Authorities go to the
lord,
authority.
subsequently.
Sorry, this type of the matter, then the court will be proceeding with all bank proceedings.
No, my lord, not bank proceedings. I'm not asking a word, my lord. What is happening, my lord?
If the
Bank is turning back, my lord, from after, my lord, accepting the ODS.
Go and challenge before
Your
the
lordship,
authority.
your lordship, DRT has no authority, my lord, to deliver up and cancel, my lord, the 5 letters which I'm seeking, my lord. That only civil court which my lord has, my lord. This
Where is the recovery notice?
recovery notice, my lord, is
if the bank has not accepted your notice, the bank naturally bank has issued the recovery notice of the amount.
Yes, my lord.
Then
This is
if
the
recovery notice has been issued, then your cause of action before this court or before
Lord,
the
as of now, my lord, there has been no recovery notice issued. Secondly, my lord, there has been no rejection of the OTS on the first. My lord, after taking the money,
there is no rejection of the OTS. Why you are coming before this court? Where is the cause of action?
My lord, this letter, 19th February letter, my lord, is turning back, my lord. They are using these letters, my lord, before NCLT.
I am not satisfied.
Your lordship may kindly, my lord.
Sorry.
Lord, your lordship may kindly, my lord, visualize, my lord. The plaintiff will be in, my lord, ruins, complete ruins, my lord. It's
what you want. If you want to take
your lordship may kindly keeps it at 3, my lord. My lord, the 3 p.m. fixed matter has been adjourned, my lord. I will come back at
why? You have to wait the other advocate. What
then,
do you
Lord,
think? You are not satisfied. Other advocate will satisfy the court and order. The
then your
plaintiff
lordship
has
may
filed
kindly keeps it
the
tomorrow.
huh?
Lord, I shall come back with judgment to try and
plaintiff has filed the present suit, praying for a decree of declaration that the acceptance of consideration by the defendant bank against the enhanced offer of OTS proposed by plaintiff has resulted into concluded contract. The plaintiff has also pressed for several reliefs. Full stop. The matter is fixed today for presentation of the plaintiff. The plaintiff has prayed for exemption under Section 12A of the Commercial Court Act. Full stop. Counsel for the plaintiff submit that by a letter dated 27 December 2024, the plaintiff has made a proposal for one-time settlement with the bank for a total sum of rupees 56 crore. On receipt of the said letter, the defendant bank by a letter dated 31st of December 2024 has informed the plaintiff that the offer is to be increased from 55 crore to 56 crore. with modified terms as discussed in the meeting dated 2012-2024 with the high-level committee of the top executive. It was further advised the plaintiff to deposit 1 crore towards the upfront amount as discussed and agreed. The counsel for the plaintiff and the plaintiff says that as per the letter dated 31st of December 2024, the plaintiff has deposited an amount of rupees
1 crore.
1 crore when? 1 crore.
1 crore.
But after receipt of the said amount of rupees 1 crore, the defendant bank had issued a letter dated 13th February 2025, wherein the defendant bank has informed, not 13th, second, 13th,
19th February.
21st of January. 21st of January. क्या बोला? 21st of January 2025, informing the plaintiff that as per bank policy, minimum 10% of OTS offer amount be kept as upfront amount for credit to loan account. And if the customer is not ready to deposit the above amount, minimum 25% amount be kept in lien account as upfront amount, wherein the plaintiff has deposited only 2 crore, that is 3.57% of the OTS offer. The defendant bank further informed the plaintiff that since the OTS proposal is not in the line with the discussion and the source of OTS repayment is not clear, thus the OTS proposal is not acceptable as per the policy and guidelines. Now the plaintiff has filed the suit for specific performance of contract on the allegation that once the defendant has agreed for the proposal of 56 crore, out of which the plaintiff has deposited rupees 1 crore, but on receipt of an amount of rupees 1 crore, now the defendant bank has turned down the OTS. This court, considering the above, this court find that if the defendant bank has not accepted the OTS, the court in the civil suit cannot decide the dispute between the parties. If the plaintiff is agreed with the act of the defendant bank with regard to the OTS scheme, the plaintiff has an alternative remedy, and as such, no leave can be granted under clause 12 of the under section 12 of the Commercial Code Act. Full stop. This court also find that the suit filed by the plaintiff is with regard to the repayment of the loan amount which the plaintiff is having the alternative remedy, and the suit under section 34 of the Surface Act is barred. Thus, the suit is also dismissed.
Lordship, two things, my lord. My lord appreciates the bank has initiated recovery proceedings in DRT. Thereafter is proceeding in NCLT, my lord, on the basis of these letters. My lord, a bank, my lord, cannot, my lord, first
I
of all,
pass an order.
exercising its high-handedness, my lord.
This court has passed an order.
Lordship, I kindly appreciates. On the basis of these letters, my lord, the bank is vexing.
Correct, I pass an order, you go appellate court.
Lordship, I kindly do.
Not to test the courts.
Lord, I'm not, Lord. On the basis of these letters, the bank is vexing the plaintiff. Extremely great.
Mr. Mitra had concluded his submissions yesterday.
Item number
So this is with regards to, my lord, service of the writ of summons, the order 9 rule 13, which I don't have a case to run. I'm only trying.
First
my lord.
submission is that.
I'm only trying. I don't have a case, my lord. If I can only very, very bad case I'm trying to.
No, that is different thing, but see,
I understand, my lord.
this is the LC,
Yes, my lord.
correct? And you have
I
to,
understand that the
have-
person whose money has gone, he should be
is
coming.
not care.
That is the
caring of
difficult
that.
part. Well, only with regards to the submissions made by Mr. Mitra with regards to incorrect statements, my lord.
Hmm.
The judgments, my lord, there's no quarrel with regards to proposition laid down by these judgments. Only issue, my lord. Only issue, my lord, is, my lord, with regards to service. My lord, I have filed that application before the Honorable Division Bench. My lord, upon instructions, when we realized, my lord, these statements were not correct, my lord, we withdrew that. As far as, my lord, the observations of the Honorable Division Bench is concerned, the Honorable Division Bench also suggested that we withdraw and come back before your lordship. Accordingly, my lord, we withdrew that application. Today, my lord, I don't want to rely on it. Mr. Mitra has already made protracted submissions on those statements. Yes, my lord, they are incorrect. But, my lord, going by what has been indicated in my application before your lordship, I'm not going into the merits of the case because I cannot, my lord. Only issue is whether, my lord, I have made out any sufficient cause, A, for condemnation of delay, and sufficient cause to indicate as to why I could not have entered appearance and defended the suit. Now, my lord, if your lordship is pleased to take up my application, which is GA4, from which I had made my initial submissions, my lord, the track report and, my lord, the service report of this honorable court is attached thereto. My lord, there is a distinction in, my lord, page 26, my lord.
Of
I'm so
GA3?
sorry. Of GA4, my lord.
Yes.
Opposition to ওদের opposition to ফেরত দিয়ে দিচ্ছে বোধহয় ওদের opposition টা একটু Well, in that G4, G3, কোনো proposition. Well, in that, if your lordship sees, well, there is only in the second box, neither postal acknowledgement receipt nor undelivered packet of different numbers 1 and 2. And, my lord, the e-tracking report shows there is, my lord, with the deepest of respect, the remarks is perhaps, my lord, not the correct observation. I'll indicate why. My lord, if your lordship turns over to the next page, which is the tracking report. Opposition to my lord, here the item delivery is shown at, my lord, Bangladesh, Khulna city, and not to the addressee. This is actually, my lord, a distinction to, my lord, what has been indicated in the affidavit of service, which has been relied upon by Mr. Mitra. The subsequent letters.
So when item page 27.
27, my lord, item is shown. It doesn't show its
delivery confirmed.
Yes, my lord. Lordship will see
July
location.
1634, Bangladesh. Location.
Location is Khulna city.
Khulna city.
Yes, my lord. If your lordship sees on the first entry on that page, July 8th at 4:34, Bangladesh. Location is Bangladesh, Khulna city. It's in short form, BDKH city.
Okay, Khulna city. Yes.
Now, my lord, I have relied upon, my lord, a tracking the pin codes which are available as far as Bangladesh is concerned, and from their official website. There is no pin code.
Yes, your point on.
Yes, my lord. Mr. Mitra made the point that if this pin code is incorrect, that is 9200, which is provided in the cause title, then, my lord, the subsequent communications could not have been received. So, my lord, he relied upon the affidavit of service, which is annexed to his affidavit in opposition in GA3. My lord, in this
GA3 affidavit in opposition?
Yes, my lord. Page 43 is the letter.
Yes.
Lordship has that?
My lord, now once in June 20, once the bank becomes aware that there is something pending, my lord, we become aware of it, and that is how, my lord, when we write the email, we indicate to Mr. Dey, I believe, that these documents have not received. They rely upon in their affidavit in opposition to, my lord, to the application filed by us, my lord, before the appeal court, where, my lord, the plaint is annexed. Mr. Mitra makes the point that the plaint has hand corrections. My lord, any service copy, whether it is by way of with the writ of summons or if I have received subsequently pursuant to that email, will be the same plaint. It cannot be a separate plaint. So, my lord, with the deepest of respect, perhaps that is not a confirmation that the writ of summons with, my lord, the plaint has been served. The other point is, my lord, the presumption which is there in support of, my lord, page 26 of my application is that it has been correctly addressed. Now, my lord, the tracking report at 27, if it's compared with the tracking report in the affidavit in opposition filed by Mr. Mitra at page 44, 43 is a letter.
Yes.
At 44, if your lordship sees and compares it, keeping the two documents side by side, it shows item delivered, and what is to be noted is addressee at page 44 of their opposition. I have not received that, if your lordship sees, compares it to page 27, there is no remark that the writ of summons was served on the addressee.
Yes.
Here, my lord, this letter was received.
Yes.
Their contention is, if 9200 does not exist, then how did you receive this letter? Now, of course, my lord, once, my lord, there's an awareness in the post office that this is what has happened. We have inquired. That is when this has happened, my lord. This is post I having received the communication from Mr. Dey. So that is why these letters were delivered. But, my lord, prior thereto, my lord, which is there, my lord, the writ of summons, that, my lord, could not have been delivered. The only test which my learned senior friend had to satisfy is, my lord, to rebut the doubt that I had raised apropos the pin code of Khulna, which is 9100 and which is not 9200. Because, my lord, in terms of section 27 of the General Clauses Act, it is presupposes that it has to be correctly addressed for delivery of a letter. To negate my submission that the document which was served through the department of this honorable court was not correctly addressed, Mr. Mitra has not produced any document to show, yes, it was correctly addressed. So, my lord, in order to comply with section 27, which is the presumption, if I may hand over the book, my lord, I'll just hand over this book. My lord, where any central act or regulation made after commencement of this act authorizes or requires any document to be served by post, whether the expression serve or the expression give or send or any other expression used is then, unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying and posting. My lord, if I may hand over this book. In this context, my lord, if I can establish that there is no pin code which is 9200, then, my lord, this presumption that the writ of summons along with the plaint has been served on me is dispelled. This is my only humble submission, my lord. Well, to dispel all doubts, my lord, we have also annexed, my lord, the pin code structure of Bangladesh, my lord, which is an annexure C of my application at page 31.
Yes.
There is no 9200. And in fact, the entire pin code of Bangladesh I have also annexed, which is at page 33. There is not one single pin code which is 9200. It can be 9201, 9203, but there is nothing of 9200. Mr. Mitro's reliance on, my lord, the affidavit of service subsequently, which is in support of, my lord, the affidavit, that, my lord, does not dispel the doubt created pursuant to, my lord, failing to establish that the original writ of summons with the plaint was correctly addressed and served. The presumption is also, my lord, against them, because if, my lord, it has come back as the report, office report at page 26, if your lordship considers it, it has come back as neither postal acknowledgement receipt nor undelivered packet. So, my lord, if I have not received it, it should come back either with an undelivered packet, or if I have received, the acknowledgement should come back. If it is, there is no receipt.
But again, it will take, if it is a 30 days, it is not undelivered packet, is not.
Yes, my lord. Then
what
the
is that?
presumption is there.
Then-
Now, to that, I have come up before your lordship to show that there is no pin code of 9200.
No.
That is
then-
all.
No, no, then you have to show that that was returned, it was suppressed by the,
No,
with
that
regard
I
to
will
pin
not be
code-
able to show.
With regard to pin code.
Yes, my
With
lord.
regard to pin code, sometime what's happened? If suppose you are in Calcutta 47.
Yes, my lord.
Correct. And somebody mentioned the Calcutta 48 or
Yes, my lord.
49.
It stays in that post office, it goes back
Correct.
to GPO,
It will go
and GPO then again redirects it.
direct. So it might be.
It might
because,
be, my lord.
because this section 27 regarding address, you are not it is not the case with regard to the address. It is only on the pin code.
No, no, if I may say this, well, pin code is an essential part of the address. Without that, I cannot be served.
No, it is a pin code, and with regard to the address and confirmation,
Yes, my lord.
because initially only it is confirmed.
Yes, my lord.
Subsequently, several litigation, then the postal authorities have upgraded.
Now they have said that address. That has to be there.
Now sometimes
It is.
now they give the name also.
Yes, also.
They
Yes,
give the name
absolute.
also.
The name is also given. Lordship, I leave it upon your lordship. I have nothing else to add. My lord, my lord, if your lordship deems it fit to put me on terms and then allow or disallow, lordship,
Why the bank? Why what?
No, to be honest, I have no instructions on this.
No, even though if we go in the fact, because I have dealt since that evidence. After
Yes,
the
my lord.
evidence
Yes,
has been
my lord.
dealt, it is fine. Your bank has not informed within the 5 working days.
Yes, my lord. I've seen.
The bank
I
has
have
not
seen that.
on the 5 working days. So how you
They should have immediately indicated that
as
the
per the-
documents are
as per the
defective.
UCP 6,
I had to. That's my
you have to
obligation.
inform if it is not in consonance, the document is not consonant with the UCP within the 5 working days, that has to be informed.
Lordship.
That
That is the law.
That is only your lacuna.
That is the only lacuna.
Lordship, may I indicate 2 facts, Lordship? One, Lordship, this entire story about the PIN code was not there before the appellate court.
So that's
This
a
is the
different
first
fact.
time that my learned friend has taken up this point. Apart from that, Lordship, 2 documents I shall cite. Lordship, page 63 of their application of GA3, Lordship, IA3, page 63. My learned friend has indicated that PIN codes 9200 do not exist. But
it's not my document. It is Axis
now,
Bank's
Lordship,
document.
at page 63, Lordship will see that the letter, it is addressed to
It's
the
not my
defendant number
document.
2 at PIN code,
Yes, my lord, it
and
is
top
Axis
at the
Bank.
very top, Lordship, the endorsement is there acknowledging that they have received the
Because
dark.
it's physically
Dark
sent.
received, Lordship,
At 9200.
at 9200 they have received. Lordship, they have received it.
And also one for
Also at
physical receipt, my lord. This is not a-
140,
That is there.
144. Also at 144.
That does not dispel the fact that there is no PIN code 9200. Lordship, you can call for a report
Similarly,
from
at
the
page 144.
Yes, yes.
144.
144.
144.
same endorsement.
Now, Lordship, apart from this, the submission of the defendant number 2 is that they received the plaint after the email and not with the writ of summons. Lordship will kindly see the paragraph 6 of their pleading. at page 5, Lordship, of the application for condonation
Yes,
of delay.
Mitra has pointed
Yes,
out.
Lordship.
I can see.
Their case is that they have received it. We have not supplied the plaint subsequent to the electronic mail. Then where have they received it? Must have been with the writ of summons.
So suffering for the plaintiff. So suffering for the defendant. Full stop. What is the GA? Who has filed the GA?
Well, GA3 is condonation of delay. GA4 is recalling of the.
Full stop. The plaintiff, the defendant number 2, na?
Yes.
Defendant number 2.
Defendant number 2 has filed an application being GA-COM 3 of 2024, praying for condoning the delay for preferring an application for setting aside of the judgment and decree. The defendant number 2 has filed an application being GA-COM 4 of 2024 for setting aside the judgment and decree filed by the judgment and decree, ex parte judgment and decree dated 22nd of November 2020. At the land council for the respective parties, hearing concluded, CAB.
Great.
Number 9. Especially asset matter side number 10.
Nine, nobody. 8 and 9, none logs.
Let's item number 10, my lord, we have for the petitioner.
Yes.
From the other side.
I have been led by my lord Mr. Shah. He is appearing online. I am for the petitioner, my lord. I believe my lord, Mr. Shah's network is my lord, a bit my lord.
Have affidavit filed?
Lord,
I am for the intervener, Ashika.
Who is for the other side?
my lord, on the last
Ray?
occasion, my lord, Mr. Anirban Ray and my lord,
Mr. Ray?
I'm led by Mr. Mitro and Mr. Ray, my lord. My lord, the appeal, my lord, is still pending, my lord. It was previously assigned before the division bench of Justice Harish Tandon, when Justice Tandon has also released it. Now, my lord, it is been assigned to Justice Bhattacharya's division bench, my lord. It is supposed to come up.
Now, what about this?
they can, my lord, complete the affidavits, my lord. We can, my lord.
Then gives us, my lord, 1 week's time, my lord. We'll file it without prejudice, my lord, to the appeal.
Because this is section 9, either this way or that way.
The interim order is my lord expiring. My lord, I'll tell you, lordship, my lord, this is my lord. If your lordship kindly sees the order of my lord February 11, 2025, with leave of Mr. Shah, my lord, with leave of Mr. Shah. If your lordship, my lord, kindly sees order of February 11, 2025, your lordship has not extended the order till my lord 28th of February. If your lordship is giving them my lord 1 week's time to my lord file the affidavit in opposition, let that also be my lord extended.
So appearing for the petitioner.
No, certainly.
So appearing for the respondents, and so appearing for the intervener. The counsel for the respondents submit that the respondents have preferred an appeal and the same is pending before the appellate court. Counsel for the respondent prays for extension of time to file affidavit in opposition. Let affidavit in opposition file by 1 week.
Well, 2 weeks, my lord, just
In
as a
2
measure of
weeks,
abundant
comma reply, if any, there to be filed within a week thereafter. Full stop. Counsel for the petitioner submit that the interim order granted earlier is going to be expired on 28th of February 2025, and he prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff and petitioner, the interim order granted earlier is extended 3 weeks. बोला है ना? Till 25th of March 2025 or until further order whichever is earlier, list the matter on 21st of March.
I'm great.
Hello, I am here for the plea. Before my learned friend starts, my lord, may I seek my lord an apology, my lord. Here, affidavits have been completed, We have also served within time, but by mistake it has not been filed before your lordship, my lord. I'm only filing my affidavit in reply in GA4 and GA1.
Yes.
I requested my friend to say this in person. My lord, I requested the advocate on record to, my lord, apologize in person.
Yes.
I've had a rough morning anyway.
My lord, I get completed on facts, my lord. Now, my lord, to deal with the other side's judgments. But one judgment I choose not to deal with is a judgment which was relied upon for the proposition that an order 6 rule 17 has to be heard out first, but I do not join issues with that. But why I am opposing the order 6 rule 17 application is that they are seeking to introduce new documents through backdoor, which in a commercial suit, it should not be permitted. They are seeking to introduce the plain filed in the previous suit to get the knowledge. So that should not be permitted. My lord. Your lordship's judgments are also there, my lord. I need not, my lord, labor on. My lord, that leaves us with, my lord, 4 judgments.
Yes.
But if your lordship is pleased to take a look at, my lord, AIR 1922 Calcutta 157, my lord.
Yeah,
1922 Calcutta 157. This is Biman Chandra Datta versus Pramatha Nath Ghosh.
Yes.
Has your lordship got it, my lord? I believe it's the SCC online print, my lord.
SCC online.
Yes. My lord will kindly. But this is on
1922.
1922 SCC online Calcutta 145. Yes. But all these judgments were relied upon for the proposition that some hints from somewhere will not, my lord, start the clock. When the plaintiff acquires full knowledge, then only. But kindly sees these facts. This is completely, my lord, different from us. But kindly, my lord, turns to the second page and the paragraph, the facts material for the decision, my lord. Has your lordship got it, my lord? The facts material for the decision of the question of law.
Paragraph.
I'm sorry, my lord.
Paragraph.
There's no paragraph number. It's the second page of the judgment. My lord, the second paragraph. It starts with the facts material for decision. The facts material for the decision of question of law raised before us lie in a narrow compass. One Jyotindra Mohan Datta died living as his heir, a childless widow, Pranab Kumari Dashi. The widow sold her ornaments through her maternal uncle Pramotha Nath Ghosh and made over the sale proceeds to him to be deposited on her behalf in Hazaribagh Bank. So the widow's ornaments sold, widow's maternal uncle has been given the money to deposit. The deposit was made on such and such, and the account was opened in the books of the bank in the name of Pramotha Nath Ghosh, the maternal uncle, on behalf of Srimati Pranab Kumari Dashi. Pramotha Nath Ghosh, who is the defendant in the litigation, was consequently the only person who could operate the account. Pranab Kumari, now the widow dies on 21st November 1910, and a sum of rupees 800 stood to the credit of the account on that date. On 22nd December 1910, Pramotha Nath Ghosh, that is the maternal uncle, withdrew the money from the bank. The plaintiff, who is the brother of the Jyotindra Mohan Datta, the deceased husband of the lady, in her admitted heir-in-law, he commenced the present suit on 6th October 1915 on the allegation that the money belonged to the sister-in-law, that it has been misappropriated by the defendant. So the facts are, widow had certain ornaments. That ornaments were sold, given to the maternal uncle who opened a bank account, who operated that account. After the widow passes away, husband's brother sues because the ornaments were from his side, from the husband's side. So after passing of the widow, he will get. In these facts, the court held that the knowledge of the plaintiff could not be there because somebody else was operating the bank account and he could not be there. So kindly sees the findings straight away. But if your lordship kindly now looks at,
page 4. The page number is on the top left. Page 4, there's a page break where page 893 is given. Just the paragraph above that, it starts with, it has been conclusively established. It has been conclusively established in this litigation, notwithstanding the allegation of the defendant to the contrary, that the disputed money belonged to him, but belonged not to him, but to his niece, and had been fraudulently misappropriated by him. The true character of the transaction between him and the niece was specially within his knowledge, and he could not take full advantage of the death to set up a false claim with impunity if he could. The fraud of concealment of the true state of facts has been preserved by him not only up to the time of the present suit but also during its progress. The burden consequently lies heavily upon him to establish not that the plaintiff had clues and hints, if vigorously and acutely followed by him, might perhaps have led to the complete knowledge of the fraud, but that the plaintiff had clear and definite knowledge from the facts which constituted the fraud at a time anterior to the period of limitation. From this point of view, the defendant is in an inextricable difficulty. In the first place, he did not set up such a defense in his written statement, for the obvious reason that such defense, if taken as an alternative, would have seriously imperiled the success of the substantial defense, that the claim was unfounded and he himself had committed the fraud. In the second place, he had not adduced evidence to substantiate such an alternative defense. He is thus inevitably constrained to rely upon isolated fragments from the evidence adduced by the plaintiff to enable him to discharge the burden of proof. Then kindly skips the next sentence, the sentence starting with he contends. He contends that the plaintiff had knowledge of the deposit and withdrawal early in 1912. But this is clearly insufficient. The account stood in his name, coupled with the statement that the deposit had been made on the behalf of his niece. He alone could consequently operate the account. The withdrawal by him, and this is very important, my lord, the withdrawal by him was thus not necessarily an act tainted by fraud. Indeed, he has nowhere asserted that he entertained a fraudulent intention at that time to misappropriate the sum. In fact, he alone would have to withdraw the sum from the bank before he could make it over to the rightful owner. We have thus no allegation by the defendant, much less any proof by him as to precise time when he committed the fraud. Apart from this, he had throughout concealed the fraud. So, it is in these facts that section 18, as it was then in the previous act, the benefit was given. But for the facts here are completely different. Here, by that letter of 14th of March, he gave the details of every invoice, and he said that there was an assignment and I am putting you on formal notice of the assignment. So all the facts, all the knowledge was already there. So we cannot now feign ignorance just by jugglery of words that there was a suspicion, I got hints, I got some clues. Those are submissions from the bar. The plaintiff otherwise knew entire thing. The plaintiff from the letter, it's apparent from the letter.
I've come to learn.
No, the letter says otherwise. Now we'll kindly have a look at the next judgment. But this is 1960 Calcutta. 1960 SCC online Calcutta 220. Paragraph 45 was relied upon.
Yes.
Now kindly takes a look at paragraph 8 of this judgment. But before I take your lordship to this two paragraphs, in a nutshell, may I indicate the facts? It was a suit or a claim filed by the official liquidator.
Filed by?
The liquidator.
Liquidator.
The official liquidator for misfeasance against some of the directors in respect of a company which went into liquidation. The issue was that whether the proceeding was barred by limitation, because the act provided that from 3 years one has to initiate. But here the court held that benefit of section 18 should be granted because the liquidator did not have knowledge of the account entries which were there in the books of accounts, and when those surfaced, it is only thereafter that the liquidator had got the knowledge. And the facts here are completely different. There's no other latent entry in any books, but which would enable the plaintiff to break through that window. But your lordship will see the facts of this case at paragraph 8. And this is where I want to just place this paragraph only. The more important question, therefore, is whether the liquidator was kept from the knowledge of his right till March 25, 1950. On this point, I shall have to consider the correspondence that passed between the liquidator on the one hand and the appellant on the other. So, the correspondence which would show whether he had knowledge or not had to be considered. This is where I exactly come in, where the 14th March correspondence would show otherwise. Then kindly permits me to read on. It appears that very soon after the winding up order, liquidator addressed one letter to such and such requesting him to furnish a statement, unlike us. Then the next sentence, this letter was addressed to A.K. Das and some other directors, but the appellant's name does not appear. Again, unlike us. Then two, another letter was written by the liquidator to A.K. Das alone, requesting him to furnish particulars about the 6 loans. So he was not aware of that. Then kindly skips 2 or 3 sentences, then on this ground, A.K. Das regrets his inability to give any information of the matters referred to by the liquidator. Then the third letter. The third letter written by the liquidator to the appellant alone is dated such and such, asking the appellant to explain certain irregularities. Then fourth letter written by is addressed to the appellant alone. By this letter, the appellant asks appellant to supply him with the particulars of certain ornaments and goods pledged. Then the fifth letter, again asking for particulars, and the sixth letter, is to the appellant asking for particulars once again. So, it is on these facts that the finding is there in paragraph 9 that if your lordship kindly takes a look at page 8,
yes,
just above the page break of where page 830 is written, I have no hesitation in holding that this statement in the solicitor's letter, where they refused to divulge, was a false statement and it was calculated to mislead. I'm sorry, page 8. There's a paragraph 9, there's a page break, page 830 in the middle. The line just above that, I have no hesitation.
Okay.
Has your lordship got it?
Yes, I have no hesitation.
I have no hesitation in holding that this statement in the solicitor's letter was a false statement and it was calculated to mislead the liquidator and put him on a wrong track. It is significant with regard to the loans purported to have been granted by the bank between March such and such to April such and such. The appellant solicitor categorically states that they do not all concern the appellant. In respect of these loans, the appellant does not state that he could explain them from his memory, nor does the appellant ask for any inspection. So, all your lordship would find the findings are with regard to the knowledge that they could not have known. Kindly turns over to the next page, page 9, only one sentence from this. Page 9, third line from top.
From bottom?
From top. Third line from top. The sentence starting with, I have therefore no hesitation.
Yes.
I have therefore no hesitation in holding that the appellant was misleading the liquidator by stating that in respect of the loans he was not. So, here the court found, and why the benefit of section 18 was granted, because somebody whom he was suing was misleading him constantly in suppressing the information. Completely not our facts, nothing related to our facts. These are the two judgments. Then the next one. And they were asking for information which were suppressed. Then, if your lordship kindly takes a look at the next judgment, which is Chaitanya Das. This is 1938 Calcutta. AIR 1938. SCC online is 1937 SCC online.
38.
This is a 1937 SCC online Calcutta 219, which is reported at AIR 1938 Calcutta 263.
Yes. Yes.
Once again, this was cited for the proposition of section 18.
18.
Yes. Kindly takes a look at paragraph kindly takes a look at the second page of the judgment. Just to give your lordship a bird's eye view of the facts, this was a second appeal. My lord, this is a case where, my lord, if your lordship kindly takes a look at from paragraph 1 on the second page, just above the, my lord, page break of page 514. One Horipodo Ghosh, husband of defendant number 2, had a Mokorari tenure, it's a lease under defendant number 1. Then that was sold. He sold it to the defendant number 3 on such and such, corresponding to such and such. The Kobala was registered and registration fee was paid. Kindly see the next sentence. In the record of rights, which was finally published at about this time, the name of Horipodo Ghosh appeared as a tenant in respect of the tenure. So somebody else's name was appearing. In 1923, the defendant number 1 instituted a suit against Horipodo Ghosh for recovery of arrears of rent of his tenure for the year such and such, and obtained a decree on such and such. In the same year, he made an application under Bengal Tenancy Act for settlement. Then the next sentence, well, on December 21, the defendant number 1 put the rent decree into execution. On January 29, 1924, he made an application to the revenue officer for substituting the defendant number 3 on the ground that the defendant number 3 was in possession of the tenancy by purchase from Horipodo. The application was allowed. On the same day, the proceeding under 105 was compromised and the defendant number 3, between the defendant number 1 and the defendant number 3. By the compromise, the tenancy was admitted to be Mokorari and the defendant number 1 gave up his settlement of fair equitable rent. On such and such, the application for execution of the decree was allowed to be struck off. Then thereafter, Horipodo died leaving defendant number 2 as his heir. In May 26, the defendant number 1 made another application for execution of the rent decree. Then the execution petition contained a statement that the defaulting tenure belonged to defendant number 2, the judgment debtor, and was verified by the agent to be true. Then the self-proclamation was given. But it is in these facts that, my lord, your lordship will kindly now take a look at the next, skip 2 or 3 sentences and thereafter the next sentence. The plaintiff instituted a suit. Plaintiff thereupon instituted a suit in 1930 to recover possession of these lands from him. But 6 lines from top on that page.
Which page?
My lord, page 3.
Yes.
7, 8 lines from top. My lord, the sentence starting with the plaintiff thereupon.
Yes.
Instituted a suit in the year 1930 to recover possession of these lands from him. This suit, however, was dismissed on the ground that the plaintiff had acquired no title to the tenure by his auction purchase, as the sale was in effect a sale not under the Bengal Tenancy Act but a money sale, and the judgment debtor had no saleable interest. By this time, the defendant number 1 had realized such and such as rent from the plaintiff. After the dismissal of the suit brought by him against such and such, the plaintiff raised the present suit. So one suit dismissed, thereafter the plaintiff files another suit in the court of Munsif for the refund of money paid by him to the defendant number 1 together with interest, in all rupees 600 in alternative possession of the tenure and the declaration. The trial court passed a decree for rupees such and such against the defendant number 1 but dismissed the suit against the other defendant. The defendant number 1 appealed to the lower appellate court. The learned judge who heard the appeal had set aside the decree of the trial court and dismissed the suit against defendant number 1 also. So the plaintiff filed the second appeal. So, my lord, here your lordship would see from this longish first paragraph is that, my lord, the issue was regarding one sale already executed, somebody was else in the possession as a tenant, rent collected for a particular period of time, yet the registration was in somebody else's name. So, my lord, it was in these facts that, my lord, the suit was dismissed against the plaintiff. Now, this was undone by the honorable by the High Court in second appeal. And it is in these facts that kindly now turns to, my lord, page 6. But towards the middle of the page, your lordship would find there's a page break of page 520.
Page 520, yes.
Yes. After that, my lord, the paragraph starting with as regards.
Yes.
As regards the contention of the learned advocate for the respondent that
They had relied upon.
they had relied upon.
They
So
relied upon.
they had relied upon.
Yes.
Now, kindly see in which facts. Relied upon by the respondent that the plaintiff's claim is barred by Article 62. The position is this: after auction purchase by the plaintiff, the defendant number 1 went on receiving rent from the plaintiff for the tenure on the footing that the plaintiff has acquired good title to the tenure by auction purchase.
Correct.
he suppressed from the plaintiff the fact that before execution was started by him, the defendant number 2 had lost her right to the tenure and that the defendant number 3 was the real tenant of the tenure. Assuming Article 62 of the Indian Limitation Act applies to the case, from the facts of this case, it is clear that the plaintiff was entitled to the benefit of Section 18. It was argued on behalf of the respondent that the fraud of the defendant number 1, if any, became known to the plaintiff when the written statement in the suit was filed by the plaintiff. The learned Munsif has rightly pointed out that the plaintiff had then no definite and clear knowledge of the facts constituting the fraud. That mere fact that some hints and clues reached the plaintiff, which if followed up might have led to the complete knowledge. Now, my lord, kindly takes a look at the page number 11. Well, the last paragraph at page number 11, it's starting with "in my opinion."
Yes.
In my opinion, the delay in instituting the suit has been sufficiently explained by the plaintiff, and it would not be proper ground for throwing out the plaintiff's suit. After the plaintiff got the sale certificate, the landlord did realize rent from him for about 3 years, knowing full well that he had no right to receive the same. It was an act of fraud on the part of the landlord, which lulled him into security and led him to believe that it was only a third party who was obstructing him to get possession. He had instituted a suit against a third party who set up a title of the real tenant. And it was in course of that litigation that he came to know of the real state of affairs. Assuming Article 62 of the Limitation Act applied for recovery of money received by the plaintiff, I hold that the plaintiff can get extension of time under Section 18 as against the defendant number 1 who, kindly marks this, by fraudulent misrepresentation and suppression of truth subsequent to sale kept the plaintiff out of his knowledge. None of these ingredients are there. There is no fraudulent misrepresentation, there is no suppression, there is no subsequent event, and there is no act on the part of the defendant to keep the plaintiff out of the knowledge. So these judgments are not at all opposite to the facts of the case.
Yes.
None of these ingredients are there. The plaintiff knew. He gave the details. He told me to pay. He filed a written statement in the previous suit. He could have come up before that. He could have filed a counterclaim before that. I'm only left with one more judgment. This is 2021-17 Supreme Court cases, page 100. Relied upon for the proposition that limitation is a mixed question of law and fact.
Yes.
But once again, before taking your lordship to the judgment, in a nutshell, the facts. The plaintiff had instituted a suit to set aside a registered document. That registered document had taken place long back, 12-13 years back. So the defendant filed a order 7/11 saying that the suit is barred by limitation. In those facts, the plaintiff had proved that he had no knowledge of that document, and only when he gathered knowledge from a different proceeding, where that was set up as a defense, that the plaintiff gathered knowledge and immediately filed the suit thereafter. So the court had held that because the knowledge, the factum of his knowledge is a mixed question of law and fact, so in a 7/11, it cannot be. So I'm not taking you to the lordship. Kindly takes a note, paragraphs 4 to 6 would give you lordship the facts of this case where the knowledge was not there to the plaintiff. So it is in these facts that the court has held that limitation is a mixed question of law and fact. So unlike ours.
Yes. That's all.
That's all.
Lord, just one sentence, my lord. Mr. Mitro's leading me, but I should just, my lord, page 262, that document, that letter, where Mr. Gupta says, I had all knowledge. GA1, page 262.
I have not cited any new judgments. So
No, but he's relied upon facts again. He himself said that I've concluded my reply on facts. Now I'll reply on law. So, my lord, only. Yes, my lord.
Yes.
Kindly, my lord, have a look at that. My lord, the last paragraph at page 262. The 6th line from top of the last paragraph. Furthermore, Furthermore, we had come to learn from logistics service provider that you have, being in possession of the original documents, already taken possession of the goods. This is, my lord, the knowledge that he is talking about.
Correct.
Now, my lord, I ask myself, my lord, I have come to learn from some logistic provider that the goods have been removed. Based on this knowledge, my lord, would I be able to affirm my plaint as true and correct to my knowledge? If I was to come and give evidence, the first question he'd ask me, how did you learn about this? And my reply would be, I learned from a logistics provider. My lord, that would be hearsay. At this stage, even going by this letter, I did not have enough material, my lord, to prove my case. Because I can only prove my case as a plaintiff when I have full knowledge. And my lord, this is not an anomaly, because if your lordship sees, my lord, the criminal complaint which I filed after this, even in that criminal complaint, I say I'm apprehending that the goods have been removed. The warehouse operator, namely defendant number 4, is not allowing me to go into the warehouse to see my goods. Your lordship will see the criminal complaint after this also. It's not that my goods have been taken away. I'm apprehending what is the fate of the goods. Well, that's the and I haven't even named Mr. Gupta's client in my police complaint. Well, the complainant would try and implicate as many people as possible in his FIR. But I didn't even have an idea about them. So I only named the warehouse operator D4. After the investigation, it so turns out.
See, fact, Mr. Mitra has already
Very,
argued. What
very
you-
well.
Nothing on you.
Based on this page, I could not have even proven my case.
Okay, that's all.
And my lord, the plaint which you are, my lord, bringing on record, number one, my lord, it's a record of the court. Same court, my lord, of a different proceeding. Secondly, in GA1,
What?
my lord, the plaint, old plaint from where we got full knowledge. We are, my lord, proposing to bring that on record by way of our amendment. Mr. Gupta saying it's a new document. My lord, 2 points on this. Firstly, my lord, it's a record of the court. My lord, same court of a different proceeding. Secondly,
This
in
is already
GA1,
submitted. My opening submission was it's a new document.
I must point out,
I've already given
in
reply.
GA1 of this, my lord, suit, this suit, we have filed a supplementary affidavit long back. Soon after, my lord, the GA was filed. In that GA supplementary affidavit also, my lord, this is on record. So it's also a part of this suit. Not only, my lord, a part of the earlier suit, but it's also part of this suit. Kindly.
So why you are not disclosed?
Sorry?
Why you are not disclosed?
My lord, we have referred to it. We have pleaded about it.
Okay.
We have it's referred to in the plaint. It wasn't annexed as an annexure, but it's described in the plaint. Okay. We have pointed out all those relevant paragraphs.
Suffering for the plaintiff census. Any written notes of argument filed? No filed.
My lord, kindly give us some time.
Census and suffering for the plaintiff, census and suffering for the defendant. The defendant has filed an application being GA1 of 2020.
Defendant numbers 1 and
defendant number 1 and
1 and 2. But there are 3 suits. One I am appealing for the defendant numbers 1 and 2. The other 1, 2, 3. There's one defendant.
Defendant 1 and 3.
Item 12, 1 and 2.
1 and 2.
1 and 2 in item 12 and 1, 2 and 3 in 11 and 13.
I must also, my lord, disclose I have 10 crores of Mr. Gupta's client who's on anticipatory bail in connection with this transaction.
That proceeding has been dismissed.
No.
1 and 2
Yes.
has filed an
It is
application
pending. 10 crores are with me.
for rejection of plaint. Full list of hearing concluded. Full list of counsel for the parties are directed to file their written notes of argument within a week. Within a week from date.
Within a week, my lord.
Full list of list the matter on
Goods removed.
7th of March 2025 under the heading to be mentioned for written notes of argument by the parties. By both the parties.
Your lord, also record that we have filed the affidavit in reply.
Affidavit in reply filed by the plaintiff be kept in the record.
So, my lord, other applications should await, my lord, for the fate of this.
4 has been heard.
No, the amendment.
Again, so your lordship is hearing the amendment and the
That's
711.
right. Yes, only 711 and amendment. I am not.
There are
taking-
other GAs, my lord.
Other I am not taking.
2, 3, 4. 2 to 4.
The demurrer and the amendment.
Amendment.
And after this, my lord, we'll want to press for our application, my lord, for interim relief.
That's
my lord,
subsequent.
Yes, because our goods have been taken away. The security which I had.
So, with regard to which is GA1 is the rejection. No. GA1 is the injunction.
GA1 is injunction.
GA2.
GA2 and GA3 are
That is the
applicable.
problem. Kahan hai?
Who is the
Alag alag
demurrer?
to?
by the defendant numbers 1 and GA2 is my demurrer application, my rejection of plaint.
GA3 is the deletion application.
GA3 is, I think, Mr. Bandyopadhyay's application for
No, no,
deletion
no,
of the
no, no,
defendant.
no, no, no. GA3 is also your application for
GA
deletion.
GA5 is zero.
J1 is the injunction application.
GA1 is
GA1
the
is
injunction.
J2.
GA2, my lord, is the application of Mr. Gupta's client, the demurrer, Order 7, Rule 11.
J2 and
GA3
and amendment.
Amendment is GA4, my lord.
GA4.
Madam, GA3 and GA4 hearing GA3
GA2 also.
GA2 also, my lord.
GA2 and GA4.
GA2, 3 and 4.
3 table.
But 3.
My lord, therefore, for deletion of their name.
I have not
No, no, your lordship is not 2 and 4.
GA2 and GA4 hearing concluded CAV file return notice.
Yes.
Wait.
2 and 4. Good.
बुलाओ डेट देगा.
Lord, I appear for the plaintiff led by Mr. Thakkar.
Yes.
Lord, he had mentioned in the morning, your lordship, my lord, asked us to be present, my lord. We had given them a notice. They had naturally opposed, my lord, indicating that, my lord, there's a direction of the honorable division bench. Only time for today, my lord, tomorrow, day after, whenever. But we are not.
Well,
taking
it
time,
is
my lord,
not
we
just the division bench, my lord. If your lordship kindly takes a note of the order of 17th of February. Lord,
yes.
Without getting embarrassed when I'm saying, my lord, in the last occasion, kindly have a look at, my lord. This was a fixed, that day the matter was fixed as well.
This was not fixed.
No, that day it was not.
Yes.
So plaintiff sought an accommodation. I am suffering an order of injunction.
Yes.
And my lord, your lordship will see, it is not that Mr. Thakkar, Mr. Thakkar has made substantially argued, I am suffering the order of injunction. And my lord, kindly see, my lord, kindly see who appears on behalf of the plaintiff. Mr. Gupta is here. Mr. Thakkar has a leader. Mr. Thakkar has somebody as competent as Mr. Gupta assisting him.
Mr. Thakkar is, my lord.
But Mr. Thakkar has mentioned the matter.
But just not today, my lord. Tomorrow he will be there whenever, if your lordship's
No, but
business.
that is the difficulty. But I can understand, my lord, the business of the court does not permit these kind of matters to be reached. So your lordship can understand, my lord. I can appreciate, my lord. Possibly, I'm sure he's in some difficulty, but kindly also understand our situation.
That's correct. That's correct. परसों क्या Friday क्या है? अच्छा है, fix है. Fix है. कल 3:45. कल tomorrow 3:45.
Grateful, my lord.
So appearing for
The 3:45.
Thursday. That's the only.
No,
Wednesday.
No, 3:45. If there is not a 4:30, if 3:30 full court reference, my lord, then we take.
Wednesday we can.
I don't think full court reference.
Yes, tomorrow
Your
3:30.
Suffering for the plaintiff, suffering for the defendant 1, 2, 3, and 5. Suffering for the defendant number 6 and 7. Suffering for the defendant number 10. Full stop. 11 and suffering for the 11 and 12. Full stop. Though the matter is fixed today as a specially fixed matter at 11:30 p.m. 11:30 a.m. But due to some personal difficulties of the London Council appearing for the plaintiff, is not in position to appear before this court and accordingly prays for adjournment. Considering the submission made by the counsel for the plaintiff, for the interest of justice, the case is adjourned. Let the matter appear tomorrow at 3:45.
I'm so grateful to your lordship. Deeply obliged for the kind act.
हाँ वही 3:45. और कुछ नहीं, एक 2 PM का कुछ एविडेंस आज का. नेक्स्ट कहाँ से कहाँ चले जाता 14.
My lord, I am appearing on behalf of the petitioner. My senior counsel his legs are busy in some other court. So I am taking for a not.
Who is for the plaintiff?
For the plaintiff.
My lord, I appear for this one.
Yes.
My lord, for not today because my senior counsel is busy in some other courts. That's why taking a not.
Yes, Mr. Kumar.
My lords, no objection. My lords, it's a short matter. If my lords may fix a particular time and date.
Time and date is the problem. As
That's
per the
fine.
prayer made by the counsel for the plaintiff, sensation suffering for the plaintiff, sensation suffering for the defendant. As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 10th March.
Much obliged.
My lords, 10th March, I have few matters. I'll be traveling out. My lords, any date other than 10th, subsequent to that, my lords.
11th.
My lords, 10th and 11th, both the dates.
Then
So,
14 is open. Then come on 17th.
please, my lords.
17th March. Next.
Your Lordship, item number 15 is that recalling application
Huh?
that Mr. Dotto on Friday had argued. I am for the plaintiff. It's my recalling application, Your Lordship.
You are recalling application.
Yes, Your Lordship.
15.
Mr. Dhruvo Ghosh is appearing online, Your Lordship. He's
Yes.
leading in the matter.
Rashri Datto. Want to argue the matter on the point of mandatory of the present application. Yes.
Yes, I am for the.
You want to argue the matter on mentality. Yes. What is the point of mentality, sir?
My lord, kindly before this, I want to place certain points that I missed on the last occasion. My lord, kindly come to our appointment letter at page 92 of volume 1 of their application.
You are appearing for whom? Against whom?
I am appearing for defendant number 2, Regal Container. Before coming to the question of law, I want to draw your lordship attention to certain factual aspects which will lead to the.
Yes, which one? Which one?
My lord, kindly. The first paragraph. Last second
opposition of Mohammad Alamgir.
No, this is the appointment letter of Regal.
Opposition of Mohammad Alamgir.
No. This is not the opposition. This is the application. Their application for recalling
GA7.
volume 1. Yes, GA7.
Page
92.
Yes.
My lord, the last two lines. It is the cross trading direct calls and under other arrangement. This is the appointment letter dated 8th December 2020 by issued to the Regal Container, that is defendant number 2 by the Nepal Shipping, and it has been endorsed by their erstwhile general agent defendant number 1, River Edge. My lord, here the trade services under the direct calls or under any other arrangement made by the liner management and
Where from you are getting?
I am reading out from the first paragraph. We, the Nepal Shipping, the first paragraph, Nepal Shipping Multimodal Transport Private Limited operating line services under the banner of Nepal Shipping Lines hereby appoint your esteemed company Regal Container as our booking agent for the Republic of India for our ship containers vessels, non-vessels operating services, freight services, etc., and or cross-trade services under the direct calls and or under any other arrangement made by the lines management and under direct supervision of our general agent, River Edge. Secondly, second point, the next page, page 93.
1, 2, 3, 4. See, the fourth line. Acha, river edge, the fourth paragraph, last but one. River Edge Shipping Private Limited Kolkata and arrange to deposit the same, that is the money they will receive in the name in the bank account of the general agent of River Edge Shipping Private Limited. Which paragraph? That is fourth paragraph. 1, 2, 3, 4, fifth paragraph. You are to collect.
You are responsible to collect.
You are to collect on behalf of line THC, terminal handling charges, container, damage, all those are things, cargo, when applicable as per the line's tariff in the name of the general agent River Edge. In the name of the general agent River Edge, it is very important.
Correct.
Kolkata, and arrange to deposit the same in nominated bank account of the general agent River Edge Shipping Private Limited, Kolkata. Seventh, eighth paragraph. It has 1, 2, 3,
Yes, then
5, 6, 7 paragraph. Invoicing will be done by the booking agent in the name of the general agent River Edge Shipping Private Limited, Kolkata, and will be deposited in the nominated bank account of the general agent. That is River Edge, the defendant number 1. So, my lord, I was acting under the direct control of their general agent, that is defendant number 1. The facts I want to draw from this. Now, the second, the addendum. In addendum also, our arrangement of sharing of profits, it is at page 95. Our arrangement of sharing profit. At the first paragraph, last but 3 lines upper. To other destinations as applicable on the basis of sharing gross profit on 50-50 ratio basis between Nepal Shipping and Multimodal Transport Private Limited, River Edge Shipping Private Limited, Regal Container Private Limited as applicable in the case of cargo bound to Indian port. 50% profit shall be shared by the Regal Container and River Edge. So 50% goes to the Nepal Shipping, that is pro forma defendant number 3, and the defendant number 1 and 2 are getting the 50%. Now, my respectful Sapachar, apart from this, I will like to draw your lordship's attention to the transactions I had. They are according to them, the agreement, our appointment has not been done by Nepal Shipping or by their authorized representative. That is their case. Had it been so, they would not have any transaction with us. But kindly come to page 40 of my affidavit in opposition, that on those points I draw your lordship's attention on the last occasion. My lord, at page 40, that is the amount on the deposit side, 892684, dated 23/2/2021.
yes,
That is Nepal Shipping. This is the deposit.
yes.
These are the accounts for conciliation that has been shared. So from there, I am relying upon that. At page 42, 482971.
No, this amount,
Had
which
been-
transaction, whose bank account is there?
This is the bank
This
account.
bank account belongs to whom?
These bank accounts belongs to Regal Container.
No.
Nepal Shipping paid us.
So you are appearing.
Yes.
It is your client.
It is my client.
Client. So, 23rd February, 8,92,000
Yes.
received by you.
That is the deposit. Yes.
Deposit.
Deposit.
You have received from this Nepal Shipping.
Nepal Shipping.
Then
And another at page 42 also.
42.
This is 3321 482971.
3321. Yes.
And another is here is leverage. It is leverage. That is at page 43, 10C2021, 35 lakhs.
Page?
Page 43, 10C2021.
10.3 to the leverage has deposited.
You deposited. Show
35 lakhs.
Show
Yes.
had it not been any relation with us, the transaction would not have taken place.
Okay.
I am therefore harping on that thereafter I am relying upon their my lord their prayer. That is, they want to get a declaration from this honorable court that the principal agent, that is the defendant number 1, shall not be will be precluded from acting as an agent. So they want to terminate the defendant number 1. Their plaint has been annexed না আমি প্রেয়ারের পোর্শনটা দেখাতে চাইছি the prayer portion of their plaint. My lord, kindly come to page 73 of volume 1 of their application.
Yes.
Prayer B. A decree of permanent injunction restraining the defendant and each one of them, their servant agents assigns and all other acting for and on its behalf from acting and or holding itself out as an agent of the pro forma defendant and from performing any act in relation to the agency agreement dated 10th March 2019. That is the agreement between
Yes.
that is the they want the termination of the agency of the principal agent. Now the termination of the principal agent, now what is my status here? Since I was engaged to work under the direct supervision of the principal agent, my character is that of a sub-agent. Under section 191.
Who is the principal agent?
Principal agent is the defendant number 1.
Correct. Yes.
I am the sub-agent. Therefore, under section 210 of the Contract Act, well, it is marked, I beg your lordship's pardon.
Contract section
210.
Yes.
The termination of authority of an agent causes termination of the authority of all sub-agents appointed by him. So, what is the practical difficulty I am getting here? If the defendant number 1 be declared not to act as a principal agent of the pro forma defendant number 3, I will not be able to get my claim. I have claimed twofold claim, one from pro forma defendant number 3 and
from principal agent, I will not be able to get my claim from the principal agent. By the prayer B, they want to also terminate us. So that's why.
Kindly come to the prayer B.
Prayer B of the plaint.
Prayer B of the plaint. Kindly come. A decree of permanent injunction restraining the defendant. Who is the defendant?
Even in this here, this was the prior to amendment. The defendant number 1, that is the principal agent.
Correct. Defendant number 1. And each of them, their servant, agent, assigned, and all acting on his behalf, holding itself an agent of performer defendant, and from performing the act in relation to the agreement dated 10th March 2019. Where is the agreement?
My lord, this agreement has been annexed along with their amended plaint at page. It is with their plaint at page leverage at page 66
of this application.
No, they had annexed it along with their plaint. It is the amended plaint they filed there.
Page 66.
Page 66, my lord.
Of the amended plaint का है?
This is
amended plaint.
দিতে পারে এটা দিতে পারে
Page 66. इसका है वो कहाँ से है?
That is the amended plaint.
Which document you are referring? Plaint 66 is different thing. Where is
the amended plaint they served us? It was affirmed on 22nd March 2023.
Page.
Page 66, my lord.
No.
Read to 66. My lord, we both have the
amended plaint. You filed fresh amended plaint. CS 192.
Yes.
CS 192 is here.
There must be in another page. If your lordship kindly hand it over.
Page 66.
You found on 17th of February, your lordship.
Yes. No, এইখানে তো এটা তোমার আছে তো তোমরা তো আমাকে যে কপি দিয়েছো এটা তো 2nd of March 23.
স্যার ওইটা 7th তারপরে ফাইল করা হয়েছে 2nd of
হ্যাঁ
March.
2nd of March.
17th February.
Page
Amended. Yes. Page 66 is different. Details of your container. Take this.
My lord, it is 53.
53.
Yes.
My lord, this is the agency agreement
with the Nepal shipping and riverage.
Riverage, that is the defendant number 1.
Sorry, 1.
1.
Correct.
So under this agreement, they were the general agent.
Yes.
Under this agreement, the defendant number 1 was working as general agent of the pro forma defendant. My lord, in the two separate agreements, here the signatories are not only Nepal shipping but also the riverage. That is the
no. If this is the Nepal shipping, that is the performer defendant. Nepal shipping is the performer defendant, and riverage the defendant number 1.
Yes.
And the plaintiff has prayed for an permanent injunction restraining from giving any effect of this agreement. Correct.
And also terminate.
whatever it may be. So it may be termination. So it is with regard to the Nepal and riverage. Nepal and riverage. So if this court has passed any decree or whatever it is the defendant number one and the defendant for former defendant. You are not the party here.
No.
You are not the party in the agreement dated 10th of March 2019. Correct. So what is the locus now?
Now, locus now, my lord, I under my
that two agreements which you are referring to, which you are creating your right over this that two agreement, whether that has been given reference to this agreement.
No, that agreement was entered into prior to the agreement.
Correct. That is a separate. That agreement which you are referring, the addendum and another thing, thus two agreements are not based on this agreement. Neither this agreement is based on that two agreement. That are the two separate entities and the separate two agreements, separate contract. Understand? If today the plaintiff has prayed for the relief or decree, if this court will pass any decree in this, you are not been affected here.
I am affected.
How?
My lord, kindly see kindly see those agreements, my lord.
Yes,
kindly come to page 19. Here,
Yes, page
I
93.
paid the money. I acted under the agency and I paid all the money to the principal agent. I am getting
Correct. That's why what are the contact between you and the Nepal? Kindly come to the 93. 92, 93. Where is the 92, 93? GS7.
deposited to the nominated bank account of general agent.
Just a minute.
And
Yes, 93.
93.
Correct. This 93 is between
three parties.
92. Sorry. 92 is the appointment. Okay. So who has appointed?
It is appointed by the Nepal shipping, and it has been
to you.
Yeah, it has been signed by, executed by the defendant number 1, defendant number 3, and myself.
Correct.
It is at page 94.
This is between you, defendant number 1, and former defendant.
As also the defendant number 1.
Correct. Defendant number 1, defendant number 2, and former defendant. Correct. These are this. And this communication, or you are telling that this is an agreement. If this agreement is not connected with that 10th March.
It is connected with, in view thereof, that here I, under the direction of the pro forma defendant number 3, transacted with principal agent. Now, if the principal agent is precluded from acting as an agent of the
acting as an agent of what?
Of the pro forma defendant number 3.
Where?
That is the
they have not prayed for any against them 92, 93, 94. They have prayed for with regard to the 10th March. 10th March, you have not been affected. If you have been affected with that, you have a separate cause of action, sir.
My lord, I want to state that thing, that they are taking advantage of that. That's two separate agreements. My lord, if for under this agreement, December 8, 2020, if I have to settle my accounts, I require pro forma defendant number 3, I require defendant number 1.
Go with the
number
both
1.
all those things.
Now, defendant number 1, if under this
why the plaintiff will take burden of yours?
I'm coming.
In his suit.
No, I'm coming. The plaintiff is nothing but Nepal shipping here. The plaintiff has no separate cause of action against the defendants. The plaintiff is augmenting the cause of the Nepal shipping here. Now, if I have to...
Okay, if suppose, on last occasion also the same question was put to you. I agreed with you. You have a apprehension that if the 10th March agreement is set aside, terminated, whatever it may be, or permanent injunction is passed not to give any effect to the agreement. It is with the plaintiff and the pro forma defendant and the defendant number one. Correct? Now you are
Yes.
huh?
It so appears.
If so appears.
It's so
Now you are telling no, you will be affected. If you will be affected, so if this court will pass an order directing the defendant number one, what relief you will get? Tell me.
I will not be able to get any, I will not be able to enforce any of my right against the defendant number one, and that will create a multiplicity of proceeding.
You are creating the multiplicity of the proceeding instead of taking appropriate steps.
My lord,
the court cannot advise by sitting in this chair. You are creating the multiplicity of the proceeding. If you are having something, you could have. I don't want to give any advice by sitting here.
No.
On the last occasion, also the court has opened the mind, but you have taken the last the mentality. You instead of arguing the matter on the mentality, now you have again come to the same point. Again and again, I am telling the 10th March agreement, which they are asked wait for any order. 10th March, you are not the party. You are claiming you are right in terms of the August 2020, 8th December 2020. You are having an interest over that. If you are having an interest over that, you have to go and take, because this 8th December 2020 is not bearing the 10th March 1999.
No, in 8, so far as this 8 December
don't know how-
2022, the defendant number one, I will not again take up this point. I mean, on the last occasion, how I hold both the parties, Nepal shipping and the pro forma defendant.
Take appropriate step before the other
that will
appropriate
create,
steps.
if this order be passed, that will create an embargo upon the court.
How you have been embargo? Have you relied upon the 10th March in the agreement?
No, here the defendant, the defendant number one filed, signed, executed this agreement in the capacity of the principal agent.
Maybe.
So
you go challenge that agreement. You are not challenge this agreement here. You cannot challenge. You are the one of the defendant. If you have been added, you cannot challenge this agreement. You cannot sign this agreement.
My lord,
on the last occasion, I put 3 questions to you. If you have been added, what benefit you will get from this court? First thing. Second thing, if you are having claim, you cannot file a contract claim against the defendant, being a defendant. Second, third thing, you are not the party to the 10th March agreement. You are relying upon other 2 documents. In that document, the plaintiff is not a party. These are the 3 questions I am raising.
Here, plaintiff is the Nepal shipping.
It may be here, but as
Nepal shipping, but Nepal shipping is a party, and the defendant is also a party.
Maybe, but you have been added. I don't know.
And another thing, if your lordship kindly permits me, one point is there. While this is an application under Order 1 Rule 10, the liberal view, the Supreme Court, it is a very old judgment.
Court has taken the liberal view, you have been added. But now they have filed an application for deletion. Now court has to take the legal view instead of the legal view, liberal view. Now court has to take the legal view. By adding you, court has taken the liberal. Now the all the things has come in picture. Because at that point of time, if the defendant plaintiffs have been given the affidavit in opposition, all the documents would have been on record.
No, they have
now
not.
The plaintiff has come with all records.
Plaintiff has not come with any other very important document which
That's why you
my claim.
You
refutes my claim.
Correct. They refute the claim because their simple case is that first, how you have been connected under the agreement of 10th March.
No, that was open on that question was open and on the date on which the I was added. So this question, for this question, no new document has been placed before your lordship, my lord.
Okay. Next.
And that's all, my lord.
That's all. No mentality point. Yes.
My lord, may it please, my lord. My lord, I think since my learned friend is not citing any cases, in reply, I need not add anything. Only there was one factual matter, your lordship will, because our contention is that this Mr. Sardar has acted on behalf of defendant number 1, defendant number 2, and has purported to act on behalf of defendant number 3 also.
Yes.
So our allegation, Mr. Dotto's already shown my lord the facts. I won't repeat them. Only one point on the last occasion was not brought to my lord's notice. In the affidavit opposition, he has annexed a document, page 26. And at page 32 of that of the opposition, my lord, your lordship will find
yes,
there's a signature again of Mohammed Alamgir Sardar as the Nepal shipping lines. Your lordship has that?
Yes.
Now, if my lord sees my affidavit in reply, I have annexed the original of that agreement that is missing. This is that page of our reply,
90.
page 90.
19.
19.
That's
No,
at 19.
but it's paragraph, page 25 of the reply. It starts at 19, the same agreement. Your lordship sees under Nepal shipping, this next thing is not there. So we have said this is also forged. But be that as it may, my lord, as it fell from my lord, and my learned friend has also argued he's a sub-agent. So he cannot have any say in the termination of the agency of defendant number 1. Your lordship has seen page 25, compare
Yes.
it with 32 of the AO.
Yes.
This is just another instance, prima facie, that he has been trying to pass himself off as Nepal shipping, and the document my learned friend relied on in the affidavit opposition. Well, that's at page 26. No, not 26.
25. You are 25. Yeah,
It's a-
yeah. Affidavit reply.
It's a very
Page 25.
illegible version. No.
You are having the original.
Well,
of
on
this?
page 21.
The version should.
Page 21 of the opposition. He relied on this document to say that Nepal Shipping has appointed him as managing director.
Yes.
Of course, we are denying this document, but on the document itself, it says the third paragraph, the letter of authority appointment be effective from September 25 and will remain in force for a period of 1 year. So from 2018 to 1 year. And there the agreements they have purported to show are after that 1 year. And it also says that your name will be included as the member of the board. By a letter, you cannot just become a director of a company. It will have the records we have produced now. We were not allowed to produce, or we were not in a position to produce at the ad interim stage. We have produced the records. I'm not repeating that, Malad. And so on. Since my learned friend is not citing any other decision, Malad, under 151 also, your lordship has the power to recall an order if it is obtained by fraud. I'm not citing any cases, and also, Malad, that under Order 1, Rule 10, I can make a fresh application and show that he is not necessary nor a proper party, because he has admittedly no claim against the plaintiff.
This page 32.
Yes.
Of your affidavit on opposition.
My lord.
Okay.
They have interpolated the bottom right-hand corner, according to us in the reply.
You are having the original of this?
That is annexed to my reply.
I will have to take instruction.
Bring that.
But this is a side issue. It will go into fraud on the merits itself, on the legal aspect
No,
itself.
no. He has argued one point because he is telling that Mr. Alamgir Akhtar Sardar is the party in all with all the
Yes,
parties.
but he is making an agreement with himself. Your Lordship sees those two other agreements he has he is admittedly a director of Regal.
Shipping has been annexed here.
That is for 1 year.
That is
That is
1
for
year.
1 year.
Thereafter they continued, it was not terminated. And the page that is
How can he appoint
that is
himself?
at page 25. That has been, my lord, had it not been any connection with the defendant number 1, they would not have this Prabhu Bhattachan. Prabhu Bhattachan is their founder director at page 22 of my affidavit in opposition. Kindly come. This Prabhu Bhattachan in the year 2021, that is 4th June, page 22, R2.
That's the document I showed.
My lord, here Prabhu Bhattachan is their director. They mailed us to Regal Container.
Correct.
My lord, they attached this agreement. This agreement has been signed by Mr. Sardar. My lord, here for Nepal shipping, had there been this document was sent by Mr. Prabhu Bhattachan, their director, Nepal shipping's director.
Okay, whatever it may, you produce this original one. Mr. Ghosh, you are having the original of the 25?
It's annexed to my reply. I don't have it with me, but my junior might be able to.
You are having the original?
We should be having the original.
Both the persons I am fixing after next week. Tuesday I am fixing. Bring the original of this.
Very well. And as far as the page numbers, my lord, of Mr. Dotto cited, I think your lordship wrote it. We'll make a one-page note of the documents.
Come on that.
Because as
yes, sir. So suffering for the plaintiff, so suffering for the defendant. The plaintiff has filed an application. Defendant number 2.
The added defendant number 2. He's got added as 2. That's why the confusion. He should have been 3. The original defendant 2 is the pro forma.
Added defendant number 2. Plaintiff filed an application being GA7 of 2023, praying for a recalling of the order dated
21st November.
Order dated
21st November,
2023. Wherein the defendant 2023 full stop.
2022.
2022.
Page 132.
132.
Like Mr. Ghosh, there are 2 orders, part of another order as well.
Oh, I'm sorry.
What
But
is
it's
order dated?
22.
Order dated?
21st November 2022 and 9th
22.
February 23.
1st of November 2022 and
9th February 2023 at page
9th
140.
February 2023. Full stop. Full stop. The defendant number 2 has relied upon a document dated. What is the date?
8th of December 2020.
No, this one, page 26, R3.
Page 20,
R3.
that is November 27, 2020.
Yes.
Where from you get?
That is R3.
R3, page 26 of your reply.
No. R3
Affidavit
is
of the agreement number.
agreement number. Yes.
Of the agreement number SKR-NPSP 2020. But the document relied by the defendant number 2 at inner page number 7 and running page 32 of the affidavit in opposition, the signature of one Mr. Muhammad Alamgir Akhtar Sardar is appearing as managing director. as management. But in the affidavit in reply filed by the plaintiff have disclosed the same document and said document appearing at page number 19 to 25, wherein the signature of the third person, namely one, Muhammad Alam, is not appearing. According full stop. The parties are direct, as both the parties have relied upon the said document. Accordingly, both the parties are directed to produce the original of the said document on the next date fix. As hearing concluded, both the parties are also directed to come with the written notes of argument. This is the matter on is a commercial matter, na?
Yes,
on 4th of March 2024, 2025, as to be mentioned. As to be mentioned for file written note of argument as well as production of original document.
Grateful.
Testamentary matter. Item number 44 of the non-commercial.
This is the will dated 21st January 2008. My lord will find the will in page
2008.
My lord. This is died in 2023, my lord.
Huh?
This is died in 2023, 13 April 2023.
23.
My lord, will.
What is the name of Jyotirmay Barua?
My lord, will is at page 12 and 13.
Yes. Where is the name of the executor?
Page 12, third paragraph, last line.
My father legatee. Page?
Page 12, my lord, third paragraph. First page of the will, third paragraph. Where is it?
Sudeshna Jordan, probate. Where is the executor? Executor of this will. Name Sudeshna.
Sudeshna.
She is
Sole
the
executor.
executrix.
Executor is wrongly
Executrix. Yes. When he died?
Lord, page 11, my lord.
Page 11.
13th April,
April 2023. Where is the legal heirs?
My lord, para 5, widow, son and daughter, my lord.
All are there.
My lord, all are there, my lord.
No,
Widow,
no consent.
Widow consent, and she was the attesting witness. She filed affidavit and declaration.
Reena,
and citation issued to my lord, son and daughter.
Reena Barua, affidavit of consent.
Consent and attesting witness also.
Yes. And son and daughter?
Citation, my lord, issued. Good service, my lord, delivered. No caveat certificate is there in the record.
No caveat certificate. Yes. Yes. Reena Barua. So appearing for the petitioner. Petitioner has filed the present application for grant of probates of the last will and testament dated 28 January 2008 of the testator Sri SRI Jyotirmay Barua. Petitioner says that the testator has executed his last will and testament by appointing the petitioner as sole executrix of his last will and testament while possessing good health and fit state of mind in presence of two attesting witnesses. Full stop. The petitioner says that the testator died on 13/13 April 2023, leaving behind three legal heirs, that is the wife, one son and daughter. Wife has filed her affidavit of consent. Wife is also one of the attesting witnesses. She has also stated in her affidavit that The testator has executed his last will and testament in her presence and in presence of another attesting witness by appointing the petitioner as sole executrix of the last will and testament. The testator and the wife has also stated that she has no objection for grant of probate to the petitioner. One of full stop. The as none of the as full stop. Neither the son nor the daughter have filed their affidavit of consent or affidavit or caveat by raising any objection for grant of probate. Accordingly, citations were issued. In spite of issuance of citations, neither the son nor the daughter has come forward for raise any objection or to give consent for grant of probate. The department has submitted no caveat certificate dated 31st of January 2025, certifying that no caveat has been entered for grant of probate. Counsel for the petitioner submitted the petitioner has proved the will and is entitled to get probate. Heard the learned counsel for the petitioner perused the original will, death certificate of the testator, affidavit of the wife who has given consent as well as she is one of the attesting witness. The wife being the attesting witness has categorically stated that her husband being the testator of the will has executed his will in her presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executrix of his last. As the legal heirs are not come, as the son and daughter of the testator has not come forward, notices were issued, but in spite of the notice, no caveat has been lodged. Accordingly, the department has filed no caveat certificate. Considering the above, this court find that the petitioner has proved the will and is entitled to get the probate of the last will and testament. The department is directed to issue probate of the last will and testament dated 28 January 2008 of the testator Sri Jyotirmay Barua to the petitioner on completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. Well, the department is directed not to draw and complete the order.
Careful.
PLA number 77 disposed of.
Grateful, my lord.
Next.
I am for the petitioner, my lord. Yesterday, your lordship heard this matter. Your lordship was, since the testator was issueless, the mother predeceased, the wife predeceased, my lord, the father has also predeceased. I was unable to show your lordship, my lord. Kindly come to page 9, the death certificate of the testator.
Death certificate of the
testator, page 9.
Gorachand.
Gorachand.
9.
Page 9. The first annexure, annexure A.
Yes.
Left hand side, Gorachand De is the deceased, name of the deceased, that is the testator. On the right hand side, your lordship will find that the name of the father is laid Shubprakash Chandra. On the right hand side. From the death certificate, it shows that the father has also predeceased, my lord. And others, my lord, the executor's name, my lord, however, no statement has been made in the petition, my lord, your lordship.
Yes. So this is the will.
This is the will.
Will of the Gorachand.
Yes, my lord.
Gorachand Chanda.
Gorachand Chanda.
Yes. He died on. Where is the name of the executor?
The name of the executor is Somir Nawalgaria.
Where it is?
It is there in the will, my lord. The second paragraph, first
I appoint Sarad Nawalgaria and Samir Nawalgaria.
Yes, my lord.
Executor of his last will.
Yes,
joint executor.
There was a
relinquish.
The Sharad Nawalgaria has relinquished.
Who has filed this?
Somir.
What about the Sarad?
Sharad has renounced. The affidavit to that effect is there in the record. It is there.
Sharad has renounced. Yes, then.
My lord. Somir has come up before your lordship for the grant of probate, my lord.
No caveat certificate.
has been issued, paper
Yes.
publication made, everything done. my lord.
Yes. Where is the attesting witness?
Attesting witness is Ramakant Prasant. Your lordship will find second page, my lord, of the will on the base left hand side.
Ramakant Prasad.
Prasadi.
Yes.
Ramakant Prasadi.
Yes. That's
And-
all. Anything further?
No, my
Namita
lord.
Chanda is the wife.
I have stated that in the paragraph 3, my lord. The
Namita Chanda is the Namita Chanda.
Namita Chandra, predeceased on 7.
Who is she?
Wife. My lord, wife.
Yes. And no legal heir.
No legal heir. Issueless. I have stated in paragraph 1.
Consistency appearing for the petitioner. Petitioner has filed the present application for grant of probate of the last will and testament dated 13th March 2003 of the testator Gora Chand Chanda, Chanda. Chanda. Counsel for the petition submitted. The testator has appointed Sri Sarad Navalgaria as executor, failing which Sri Samir Navalgaria. Petition submitted. Counsel for the petition submitted as the Sarad Navalgaria has renounced by executing an affidavit. Accordingly, Samir Navalgaria, the petitioner has filed the present application for grant of probate. Counsel for the petition submitted. The testator died on 25th of June 2011. 2011. The wife of the testator was a predeceased to the testator who died on 7th December 2000. Petitioner says that the testator, in the wedlock between the testator and the wife Namita Chanda, no issue were born. In the wedlock between in the wedlock between the testator and the wife, namely Namita Chanda, no issue were born. Full stop. In other words, both were issueless. Full stop. After full stop, the counsel for the petition submitted that citations were issued, but none has come forward to raise any objection for grant of probate. Accordingly, the department has submitted no caveat certificate on 16th of January 2025, stating that no caveat has been made. One of the attesting witness, namely Ramakant Pansari, has filed this affidavit, stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as executor of his last will and testament. Had the learned counsel for the petitioner produced the original will, death certificate of the testator, death certificate of the wife of the testator, affidavit of the attesting witness, and the no caveat certificate submitted by the department. This court find that it is the specific case of the petitioner that the testator was issueless, and testator and his wife both have died. Full stop. After the filing of this case, citations were issued. None has come forward or raised any objection. The attesting witness has categorically stated that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as executor of his last will. Considering the above, this court find that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament dated 13 March 2003 to the petitioner on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA numbers and instances disclosed. Next.
This is my application of probate.
Yes.
This is the Bengali original will of Mr. Ashish Kumar Sen. The translated copy is also annexed. Only come to page number 22, my lord.
Yes.
This is a will of Mr. Ashish Kumar Sen, and the name of the executrix page number 24, inner page number 3. I hereby appoint my said niece.
24, page number?
24, inner page number 3. Third paragraph. Mouash Nath Sen as executrix of the will.
English will.
The Bengali registered will. This is a translated copy of the Bengali will.
Yes, I here appoints Mauas Nath.
Yes, ma'am.
Maua Nath Sen.
Yes, ma'am.
Yes.
Page number 2, inner page number 2, page number 23. The testator declared at the third paragraph, my lord, at present of my age in 72 years, I am unmarried.
So he was unmarried.
Yes, ma'am.
Okay, when he died?
Yes, my lord. He
When he died?
25th of October 2020.
25th of October 2020.
Yes, ma'am.
Yes.
Date of the will, 14th of July 2009.
Yes. How many legal years? Have you mentioned anything?
Yes, my lord. Yes.
Amrinath, elder brother, sister-in-law, and niece.
Yes, my lord.
Petitioner is the niece.
But the elder brother died on 10th of July 1996 and
Yes.
sister-in-law 27th of July 2020. But the
Correct.
death certificates were not under the custody of the propounder. At that juncture, my lord, we prayed for citation. There was an order of citation and we have published this. And there is and thereafter, my lord, the department issued the no caveat certificate.
What about the attesting witness?
Attesting witness, my lord, Pottosh Nath. That is also part of the application of probate.
Satosh Nath.
Yes, ma'am.
Yes. Census and suffering for the petitioner. Petitioner has filed the present application for grant of probate of the last will and testament. What is the date of the will, sir? Madam?
14th of July 2009.
14th of July 2009 of the testator Ashish Kumar Sen. The counsel for the petitioner submit that in the will itself, the testator has mentioned that he was unmarried. 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 The testator died on
25th of October 2020.
25th of
October 2020.
25th of October 2020. Leaving behind 2020 full stop. The petitioner has mentioned with regard to the relation of the testator being the elder brother, but he was the predeceased to the testator who died on 10th of July 1996. The sister-in-law of the testator was also the predeceased who died on 27/7/2020. And the petitioner is the niece of the testator. Full stop. As other than the petitioner, no legal heirs have come forward. Accordingly, the citations were issued. Even after the issuance of citation, none has come forward either to give consent or to raise any objection by filing caveat. Accordingly, on 10th of February 2025, the department has provided no caveat certificate certifying that no caveat has been entered for grant of probate. One of the attesting witness of the will, namely Pradosh Nath, has filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will and testament. Third, the learned counsel for the petitioner peruse the original will, death certificate of the testator, affidavit of the attesting witness, and the no caveat certificate filed by the department. Considering the above, this court finds that in spite of the issuance of citation, none has come forward to raise any objection for grant of probate. The department has also submitted no caveat certificate certifying that no caveat has been lodged. The attesting witness in his affidavit categorically stated that the petitioner has and the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA number so and so is disposed of.
Grateful, man.
Next.
So, my lord, my application for probate lordship.
Yes.
Lordship, this is a will joint where the joint executors are there, husband and wife, my lord.
Yes.
Joint testator, my lord. Testator and testatrix, joint will, my lord. My lord, there are two executors also, jointly and severally. So last occasion, because it was even filed by only one executor. So last occasion, it has fallen from your lordship that why the other executor has not come forward. I'm filing an affidavit today, my lord. She's a septuagenarian citizen, my lord, 72
Renounced.
years old. Yes, she doesn't.
Renounced.
Yes, my lord.
Yes.
If my lord kindly comes to the will, my lord, there is only one legal heir, my lord. The daughter.
Who is
Yes.
the, who are the testator? Who is the Srimati?
Mitra,
Sarojini Bhaumik.
Yes, Sarojini Bhaumik, my lord.
She is the testatrix.
Testatrix and testator, my lord, is Nirmal
Krishna
Krishna
Bhaumik.
Bhaumik, her
Yes.
husband.
Where is the name of the executors?
Executors, my lord, will find in page number 14, internal page 3 of the will, paragraph number 2.
We have paragraph 2. Swapan Kumar Mitra.
Tapan Kumar Mitra has filed this application and Bharati Bhaumik has filed the affidavit, my lord.
Correct.
My lord, the death certificate, if I may show your lordship, page number 10 is of the testator. He passed away on 21st July 2014.
And 21.
And testatrix passed away on 28 August 2021. There are
What
two
is
attesting witnesses. Both has filed their affidavit, my lord. Separate affidavit.
2007. Both the attesting witnesses have filed their affidavit.
Yes, both has filed.
And what about the legal heirs?
Legal heir, there's only one legal heir. I've mentioned, my lord, in paragraph number 5, page 3 of my petition, my lord.
Srimati Mitra Mitro.
Because
she has
my
given
lord,
the consent.
Yes, she has given consent, my lord.
Bharti Bhaumik. Mitra Mitra. Yes. That's all.
Yes, my lord.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament of the testatrix Srimati Sarojini Bhaumik and the testator Sri Nirmal Krishna Bhaumik. Counsel for the petition submitted. The testatrix and the testator have jointly executed this last will and testament of their last will and testament by appointing the petitioner and one Srimati Bharati Bhaumik as joint executors of this last will and testament of their last will and testament. Counsel for the petition submitted. The another executrix, namely Bharati Bhaumik, has submitted her affidavit stating that she has no objection for grant of probate, and accordingly, present petitioner, being one of the executor, has filed the present application. The testatrix died on 28 August 2021, and the testator died on 21st of July 2014, leaving behind one legal heir, namely leaving behind one daughter, namely Srimati Mitra Mitra. The daughter has filed her affidavit of consent stating that she has no objection for grant of probate. Both the attesting witnesses have also filed their affidavit stating that they have no objection, stating that the testator and testatrix have executed the will in their presence by appointing the petitioner along with Srimati Bharati Bhaumik, adjoint executors while possessing good health and fit state of mind. Full stop. Full stop. Heard the learned counsel for the petitioner peruse the original will, comma, affidavit of the attesting witness, affidavit of consent of the the daughter, and the affidavit of the other executor of the. This could find that the the legal heir, that is the daughter of the testator and testatrix, has categorically stated in her affidavit that she has no objection for grant of probate to the petitioner. The attesting witnesses in their affidavit have categorically stated that both testator and testatrix have executed their will in their presence while possessing good health and fit state of mind by appointing the petitioner and Srimati Bharati Bhaumik as joint executor of their last will testament. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioners and to the petitioner. नहीं क्या बोला? The department is directed to issue probate of the last will and testament dated
17th October 2007.
17th October 2007 on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate.
Grateful Lord.
PLA number 20 disposed.
Grateful Lord.
48.
My lord, this is my application for grant of probate, my lords. My lord, all legal here has given consent for grant of probate. Only thing is that the one of the property of the testator is the outside of the Bengal, my lord, that is situated at Rajasthan. If you lordship kindly take my affidavit of assets, it's annexure C. So 283(3) compliance is required.
Complied?
No.
You want that prayer?
Yes. My lords, publication is to be made.
Which?
My lord, the affidavit of assets, annexure C. Affidavit of assets, annexure C. The residential flat, sorry, commercial office, such and such, and second is Jagatpura, Jaipur. That is under the state of Rajasthan.
That is only one residential.
That is the only one property situated outside of the bank. One of the name of the newspaper I find, the Hindi newspaper is Dainik Navajyoti.
Where is the prayer?
My lord, so far as the 283 formal prayer is not there, my lords. So, no,
Then?
my lords, your lordship can.
So suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated,
my lord, dated 29th April
29th April
2022.
2022. Counsel for the petitioner submit that one of the property of the testator is situated outside the jurisdiction of outside the state of West Bengal. Yes. So the counsel for the petitioner submit that one residential flat situated of the testator situated at South Court, comma, flat number 603 at South Court -2, comma, Jagatpura, comma, Jaipur, comma, Jaipur. Counsel for the petitioner some place for leave to publish the notice of this probate and publish the gist of the notice of the present probate proceedings in the
Dainik Navajyoti.
In the daily newspaper Dainik
Navajyoti. Navajyoti.
Navajyoti. And English daily newspaper.
My lord, there is Indian Express, Jaipur.
Express, Jaipur edition, which are widely published at Jaipur, comma, Rajasthan. Consider the submission made by the counsel for the petitioner. Petitioner is granted leave to publish the gist of the proceeding of the gist of the notice, publish the notice of this proceeding in the daily newspaper, and English daily newspaper so at Jaipur. Jaipur. The petition directed to take up a petitioner within of the publication of the notice within 2 weeks from date.
I'm appealing for the petitioner, my lord.
Yes.
The appeal of dated executed on 17th June 2016. Testatrix died on 25.
What is the name of the testatrix?
Santwana Moitra.
Santwana
Moitra.
San-
Lordship will find.
Santwana.
Yes, my lord.
Santwana Moitra. Yes, where is the name of the executor or executor?
The executor name is also there in the first page of the.
I hereby appoint Subba Sinha.
Yes.
If the executive dies
I am paying
before
for
probate
citation in respect of.
citation.
Yes, my
For?
lord. Legal heirs.
None has come.
None has
How
come.
many legal years?
There are five legal heirs are there.
Where?
One daughter.
Where you mention?
Yes, my lord. Body of the petition.
Page?
Page 3, my lord, perhaps. Page 3. Yes, page 3, my lord.
None has come.
Yes, my lord. None has come. The predeceased son's wife is there. Son, grandson, granddaughter, son, and daughter. So 5 legal heirs are there.
Sense appearing for the petitioner.
But in terms of pair A and B,
Sense appearing for the
my lord, after this citation, my lord, there will be a further order to that extent for publication.
Let for citation be issued.
Otherwise, to cut short the time, I am making this.
Since where they resides?
They are all in Calcutta.
Salt Lake, Sector 3. One is Selimpur.
Yes, Thakuri.
South Kolkata. Since appearing for the petitioner, petitioner has filed the present application for grant of probate of the last will and testament dated 17 June 2016 of the executrix Santwana Mitra, M-A-I-T-R-A, S-A-N-T-W-N-A, Santwana Mitra. Full stop. Counsel for the petitioner submits that the testatrix left behind 5 legal heirs, but none has come forward either to give consent or to file caveat. Accordingly, counsel for the petitioner prays for issuance of general citation, special citation, as well as publication of the notice in the Bangla newspaper as well as in the English newspaper at Kolkata, where the legal heirs are residing. Consider the submission made by the counsel for the petitioner. Prayer A and B of the present application is allowed. Full stop. The petition is also directed to publish the notice of this case for the information on the legal heirs or the legal heirs of the testatrix with regard to instant proceeding in the English daily newspaper, Times of India and Bangla newspaper, Vartman.
এই সময় মানে it will be less cost.
এই সময় পুলিশ। Next.
Your Lordship, this is an application for grant of writ. I'm praying for issuance of citation in terms of special and general citation, my lord. The addresses of the legal heirs which are mentioned in page 4 under paragraph 8 are not known, Your Lordship. As such, I'm praying for issuance of special time.
Not known where the publication will be made, sir.
Your Lordship, I prayed for publication in the Sunday edition, Your Lordship, of the Telegraph.
Now where? If you are not known, they are residing in Delhi or Punjab or Chandigarh or anything, how it can be? Who are they? Son and daughter?
Yes, Your Lordship.
Of the testator or testatrix?
Testator, Your
Testator. And who is the petitioner?
Your Lordship, the petitioner is the person who used to take care after the son and the daughter abandoned the father and the wife. Testator's wife, Your Lordship. As such, they used to take care of them.
So where you are to publish? Known, not known, then? Where they last resided? You not mention also. Where they last resided, because the
Calcutta,
petitioner
Your
is the caretaker.
Yes, Your Lordship.
Correct. She might be knowing where the last resided.
My lord, she cannot trace it out, my lord, because they have left long back, my lord. They had left the place long back, my lord.
They left the Calcutta.
My lord, they are not even there. They tried to last the
105 Ganpat Bangla Road.
Yes, my lord.
Post office Bura Bazaar. I don't think Bura Bazaar property they will left.
My lord, then let the in Calcutta, my lord, then.
Sense suffering for the petitioner, police. The petitioner has filed the present application for grant of probate of the last will and testament. Last will and testament dated 19th March 2021. Police. The counsel for the petitioner submit that the testator left behind three legal heirs, that is son and two daughters, but the petitioner is not having the proper address of the legal heirs of the testator, and accordingly the petitioner intend to petition prays for issuance of citation. Where the citation will be issued?
Your lordship, in terms of prayer A and B, your lordship.
Issuance of citation. Consider the submission made by the counsel for the petitioner. There A and B of the application is allowed. Yes.
Great, your lordship.
So this is my probate application. There are three things. I'll come to them chronologically, my lord. The first is that on the last occasion, your lordship we filed taken out an application under section 283 for the compliance, my lord, to make a publication general citation. There were two properties of the deceased. One was located within the jurisdiction of Bombay, the other within the jurisdiction of Ranchi. Lordship had granted us that, my lord. On the immediately preceding hearing, my lord, lordship had directed us to find out from the department if there is any information which is given with respect to a no caveat certificate. Well, we have proceeded with the department, my lord. They said that there's no caveat. They filed it with your lordship, my lord. But that's the first bit of it, that compliance is done. Now, with respect to the probate application itself, my lord, the two joint executors in the proceeding are the two sons. There is, and the two beneficiaries. There is a daughter, my lord. She's also the attesting witness. She's filed her affidavit of consent also. Both are on record. She's given an affidavit as the attesting witness also, my lord. So, my lord, on the basis of that, the will otherwise is proved. The third bit of it that I was coming to, my lord, is that there is a terms of settlement that has been arrived at by and between the beneficiaries and the legal heirs of the deceased. My prayer today, I'm filing the terms of settlement also. No, my lord, I understand the scope of the probate court. I understand what is falling from your lordship. I taken out one judgment, my lord, the coordinate bench presided over by Justice Shane, wherein, my lord, it says that terms of settlement is something that the probate court would be able to look at, and if the will is otherwise proved, then the terms of settlement will become a part of the probate grant.
Relying upon 73 judgments.
So the Privy Council especially, my lord. Because otherwise, whatever is fallen from your lordship is the general law. May I, my lord, directly take your lordship to the concluding part once, my lord, before I take to the reasoning. Paragraph 1, lordship takes up once, my lord, at the first page. This was a contentious cause. Ours is not, my lord. May I just read for your lordship's convenience?
Yes, Carapet.
Yes.
But it's correct. But here there is no decree.
Because it's not a
Because they're
contentious cause.
testamentary. That's why the court has held
That's
it
right.
can be taken as it. That's correct. That proposition, if it is suit can be decreed, and the one document can be made a part of the decree. But here, it is not a decree. It is an order of the, it is a probate.
Grant of
Grant. Grant either this way or that way. The court cannot say, grant be treated along with this.
What I was thinking was subject to correction was, if it is not a contentious cause, your lordship is absolutely right. It's just the grant of probate. Once it becomes a contentious clause, it would have to necessarily become a testamentary suit. Then there is a decree. That decree, my lord, in my humble submission, would be the same as the grant of probate, but in the case of a
Same, but the decree will be as a decree order. Then the decree will pass. Probate is granted. Probate be issue. The probate is granted in terms of the so and so. Then decree will be passed, and in that will be here we are passing because in terms of the prayer, and now after my determination I am dictating the order. Otherwise the this
there's a format to it.
fiat it will go as a fiat. But taking into I find some difficulties, so I started passing an order 1 or 2 page, whatever it is. But in this probate, only this court can say the probate is granted. So we cannot go by the further document. This may be taken as I stated that the copy of the probate may be treated as a part of the probate. But how the consent will be taken?
It can be, Malad. It can be. I'll indicate why. 2 bits of it, Malad. The first is, number 1, all affidavit of consents have been given. That is a part of my PLA itself. The second is with respect to the testamentary suit itself. If my probate application would necessarily become the plaint in the testamentary suit. So
what is the consent? What is the terms of settlement?
The terms
they
of
are also in.
May I just file it for temporarily for your lordship to kindly look at.
Beneficial and legal. All beneficial and legal.
Yes, kuch.
You have the property. একজনকে রাজ্যের property দিয়ে দেওয়া
Only with respect to one property, my lord. But that is going to the attesting witness as per to another third person, my lord, by consent of all the parties to it.
That immovable property is not able to divide also.
I'm told, my lord, that it's unpartitionable possibly. That immovable property which is located in Ranchi, in respect of which we had taken out the 283 application, the 2 assets. One of the immovable assets, my lord, which is located and situated in Ranchi, the legal heirs and the beneficiaries of my lord come to a consensus that be given away. May I just take your lordship through that bit once, my lord? Lordship kindly comes to page number 5 of the terms of settlement. The last paragraph, the big paragraph, my lord. It is hereby agreed between all parties hereof that distribution of assets in terms of paragraph 7C Roman 4 and assets not specifically mentioned in the will, which as per knowledge of the parties hereof covers mezzanine floor flat at 4 Kunjlal Street, Ranchi, having a super built up area of 965 square feet in ward number 22 with holding number so and so with Ranchi Municipal Corporation are to be devolved inter alia to Kiran Bajoria, equal to 10% of the market value of the movable properties at the time of death of the testator. Fair market value of mezzanine floor as on a current date, as per valuation report dated as on 10 January 2024 of engineer Binod Kumar, the government value amalot, is 82,02,500, and the same is not less than such 10% of the market value of movable properties of the testator at the time of his death, which works out to so and so. The said mezzanine floor flat of 965 square feet at 4 Kunjlal Street, Ranchi, is bequeathed in terms of the said will to Kiran Bajoria, as the same will be conducive to permitting memory of the testator to Kiran Bajoria and shall be put to full and productive use thereof, as there is no restriction on user or such property enabling conversion of its residential use to use for commercial purpose. In view of the aforesaid discharge of Kiran Bajoria bequest to her of mezzanine floor of said immovable property at 4 Kunjlal Street, Ranchi, all other movable properties as per paragraph so and so shall be divided in equal proportion between Sanjay Bajoria, Rajiv Bajoria, Sangeeta Junjunwala. 2 sons, 1 daughter. Distribution of the assets specified in paragraph so and so shall be rupees 9,86,000 to Sangeeta Jhunjhunwala, party of the third part hereof, and rupees 22 lakhs odd to Sanjay Bajoria, party of the first part hereof, both aggregating to so and so.
So 10%.
Yes.
Of 10%
So, Malad, so
of
they,
equal movable.
so both the executors as well as the attesting witness, they enter into this memorandum of settlement. So at the very onset, I'll have to clarify to the court, I'm duty bound to Malad. We're not trying to defraud the very intent of the testator while executing the will. All that we are saying is that, Malad, if the plaint had to be approved by this court, PLA becoming a plaint had to be approved, it had to be approved by way of a decree in the testamentary suit. If the caveator, if at all they came, this had become a contentious cause, that wouldn't have been passing of a decree, that would have been dismissal of the testamentary suit. So in this case, once the decree is ultimately passed, that is, in my humble submission, nothing but a grant of probate. So what happens in a non-contentious cause and a contentious cause would tantamount to the very thing, if the decree at all is passed. If it is not passed, it is merely a dismissal. The caveats, affidavit in support of the caveat becomes a written statement, gets thus approved.
Correct.
But in this case, because otherwise I proved the will, because the attesting witnesses also come forward, there is no caveator because whoever was the first class legal heir, they've all given their affidavit of consents. This would be treated as a grant of probate equivalent to a grant of decree. So, then the grant of probate by itself, without getting into the terminology of it, would then also take into account the terms of settlement and grant be passed. But would it be your Lordship's pleasure that we take out an appropriate application for this?
On what?
On the basis of making this a part of the grant of probate. I'll bring on record the terms of settlement itself in that case.
Then it will be difficult.
Otherwise, my lord,
who is he?
My lord,
in whose favor the property is going?
Adjournment bhaiyer bo.
She's one of
the testator. One of the brother of
this
the
is
wife
wife of the brother of the testator.
Wife of the brother of
the testator.
Wife of the brother of
Sister-in-law of the testator.
So brother is not there.
Brother is not there.
So she is having
Predeceased the testator.
She is caveatable right. Sons and daughters are also there. Testator sons and daughters.
No, she wouldn't have a caveatable right.
That's why sons and daughters are not there.
Sons
Who are
no, Enar. They
are there.
They are there, but they also wouldn't have any. They are also class 1 legal.
Testator made some provision for
In
this
fact,
lady.
she doesn't come within the ambit of that Hindu
that's what I'm
Succession
telling
Act
you.
also.
She's not
This is just out of natural care and affection. If this were a transaction by itself during the lifetime of the testator, this would be covered under Section 25 of the Contract Act. But he's not there. So just to make good to her whatever services that she had rendered to the family.
Only for that. She has signed. Terms she has signed.
She couldn't have come out with a caveat. In fact, no citations would have been served on her in the first place. It's just to protect her interest. The brothers and the sisters, my lord, were the legal heirs, 2 executors, 1 attesting witness. They have decided to
4 beneficiaries, 2 sons, 1 daughter, and 3
beneficiary. Legal heir. I was relying on that because I understand, my lord, the scope of the probate proceeding is very limited. So I was relying on that judgment, beseeching only your lordship to read the grant of probate to be the same as a decree. I understand that's possibly a bit of a long shot, my lord, but
or otherwise on the basis of this, she can file a caveat. Then it can be treated as a testamentary and
she wouldn't be able to, by contract, she wouldn't be able to override the law.
That's why.
So she would not have any caveatable interest on the basis of a terms of settlement in the first place.
Be. Because in the probate proceeding, it is not. Or probate can be granted.
I was only saying, my lord, that my case is possibly a step higher than a contested proceeding. If it's a contested proceeding, it would still be understandable because somebody is coming and questioning the validity of the will. In my proceeding, my lord, all persons with caveatable interest, they're not coming.
Not like that. Because once the matter, law is settled law, how it can be unsettled now? In the probate proceeding, once the court has all 1961 and law also provides it.
Caveat and then eventually all the laws that have followed.
It cannot be unsettled. Otherwise, tomorrow everybody will come and start all the things. That is the problem.
No, this wouldn't be one of those cases of a floodgate opening, because people would protect their interest. This is a situation where I am being charitable.
Same thing has come to me. Then instead of passing an order, then I have sent to the special officer for settling the parties outside of the court. outside of the court. I don't know what has happened thereafter.
Outside the court.
We're walking back in with the terms of settlement. Here, my lord, it will, matlab, if I have to submit, my lord, this wouldn't become a contentious cause at all. Nobody's going to come forward and file a caveat.
That cannot be, because the probate cannot be treated as a decree.
In the absence of contentions on parties, without it becoming an adversarial litigation. I was only praying for this, my lord. If it so commences, we could come out with an application or come back with instructions if the terms of settlement could be given effect to post grant. Two instructions, my lord. If it commences to your lordship, we'll come out with an appropriate application within 4 days' time, or on Monday we'll file, my lord. Or if your lordship wants, we'll come back.
Application, you find an application for compromise, consent. That cannot be allowed. Then it will be complicated in future.
That would unnecessarily, my lord. But could I come back with instructions in that case? Come back to see only if this could wait it out. We'll take back the terms of settlement for the time being.
So and so appearing for the petitioner. Full stop. Counsel for the petitioner prays for time to take appropriate instruction. In view of the submission made by the counsel for the petitioner, case is adjourned. Let the matter appear on 13th March.
13th March? Only one small indulgence, lordship will record that the compliance of section 283 has been done, my lord. That report.
That already caveat.
Very.
My next matter is
I'm grateful.
very short.
Okay, but certificate is there.
My next matter is very short, only for general citation.
Huh?
Only for general citation. Next matter.
Which one?
Next matter, 52, my lord.
Give.
My lord, the testatrix is the issueless, my lord. My lord, her sister, my lord, give consent, my lord. My lord, will dated, my lord. Will dated.
What? Where is the prayer?
Prayer, my lord. Prayer A, my lord.
So and so appearing for the petitioner. The petitioner has prayed for grant of probate of the last will and testament dated 4 January 2023. Full stop. Counsel for the petitioner prays for issues of general citation in terms of prayer A.
And publication also, my lord.
Consider the submission made by the counsel for the petitioner. Prayer A of the publication is allowed.
Also, my lord.
Prayer A.
Yes, my lord.
Prayer is there, na?
Yes, my lord. Yes, my lord.
Publication is
Number
there.
54 is the letter of administration, my lord.
Publication is there.
No. Publication is not there, my lord.
Due publication, huh?
Yes, sorry. Yes. Yes, madam. Yes, madam.
Item number 54 is only letter of administration, my lord. Petitioner is the wife of the deceased, my lord. Only one son given consent, my lord.
Okay, come on Monday. Come
Just
on Monday.
2 minutes, my lord.
No, I am to say that too.
allowed my application under order 11. My lord, for that, my lord, I have filing my supplementary affidavit and evidence. My witness is here.
Yes.
Yes, my lord.
Item number?
Lord, 4 and 5, she is the only witness, my lord, so 5 also.
Separate suits?
Yes, my lord, 2 separate suits, same plaintiff, different defendants.
Okay.
No, she has already deposed. She is coming again. Okay. Continuation. My lord, will it be
Examination in chief,
continu-
resume.
Continuation to the question number.
Resume.
Shown an original document.
Sujishmita Sen.
Please tell my lord what is this document? अच्छा bracket से लिख देना shown original document.
This is some supplementary affidavit in evidence.
Shown page 4 of the supplementary affidavit in evidence. Please tell my lord who has affirmed this affidavit. Shown 6 लिखे देना 6. Page 6. Please tell my lord who has affirmed this affidavit.
Commissioner. Myself, Sujishmita Sen.
Please tell my lord when was this affidavit affirmed.
24th day of February 2025.
Please tell my lord before whom was this affidavit affirmed.
Before the Commissioner of Calcutta High Court.
Commissioner of Calcutta High Court.
What do you say regarding the contents of this affidavit?
Contents are true and correct.
Shown original document. Please tell my lord what is this document.
This is supplementary certificate or affidavit under Section 65B of Indian Evidence Act.
Shown page 4 of this affidavit. Please tell my lord who has affirmed this affidavit.
This is affirmed by myself.
Please tell my lord before whom was this affidavit affirmed.
It's affirmed before the Commissioner of Calcutta High Court.
Please tell my lord when was this affidavit affirmed.
24th day of February 2025.
What do you say regarding the contents of this affidavit?
This is for the electronic mail and the contents electronic mails. Contents are true and correct.
Yes. Supplementary judgment. Shown copy of the documents appearing as PD9 from page 1 to 59. What are these documents?
These are the bank statements, HDFC bank statements.
Please tell my lord whose bank statements are these?
Transif, plaintiff company.
Yes. Are you in a position to identify the branch provided in the bank statement of the plaintiff?
Yes, it's in Stephen House and it's operating. Stephen House.
Stephen House branch, Kolkata.
Are you in a position to identify the periods for which this bank statement has been disclosed?
It's from 1st March 2021 to 31st March 2021.
Please tell my lord, how did the plaintiff came in possession of this bank statement?
The plaintiff company downloaded this from internet.
Are you in a position to identify who has downloaded the same?
It has been downloaded by the account department by my instruction.
Please tell my lord what is the purpose behind disclosing this bank statement?
This bank statement shows that the company, we have received some money from them. The proprietor has paid some money.
By them, whom do you imply?
Proprietor Shipping.
Yes.
Proprietor Shipping Private Limited.
The printout of the bank statement same
ये
as
दोनों पहले
maintained online with the bank?
Yes, it has been downloaded same.
Yes. Lord, may this be marked as an exhibit, my lord. It's an online bank statement.
You have referred the word them.
She has answered. Please, by word them, whom do you imply?
Proprietor Shipping Private Limited.
Yes, exhibit, last exhibit क्या था? H.
Exhibit H collectively.
Not collectively.
Exhibit, one exhibit.
Page number दिए थे.
Pages 1 to 59.
1 to 59. Shown page 60. Sorry, shown PD10 appearing at page 60. Please tell my lord what is this document? Page 60.
This is the GST details, GST payment details.
Please tell my lord against whom this GST payment detail concerns.
For Proprietor Shipping Private Limited.
Please identify the period for which GST payment details have been set out.
30th June 2021 to 31st July 2022.
Please tell my lord against which invoices has this GST been complied for?
Against the invoices raised.
Are you in a position to tell my lord? No, sorry, who has prepared this document appearing at page 60?
By our account department, Transit Company's account department.
Under whose instruction was this prepared?
Under my instruction.
Yes. What do you say regarding the contents of this particular document at page 60?
These are true and correct.
Please tell my lord from where these particulars have been provided in the chart appearing at page 60.
This has been provided by the company accountant. Maintained in our software.
Maintained in your software.
In our software. Who has? What do you say regarding the contents of this document?
These are true and correct.
Lord, may this be marked as an exhibit.
Exhibit I.
Shown PD11 appearing at pages 61 to 67 of the judge's brief of document. Original lage hona. It is online print out. Please tell my lord what is this document?
GST invoices.
Yes. Are you in a position to identify against whom these GST invoices have been submitted?
The invoices, I believe, not the GST. I'm confused. Tax invoices.
Are you in a position to identify the party against whom these invoices have been submitted?
These proprietors.
Yes. Are you in a position to identify the party against which GST invoices have been submitted?
Yeah, progress shipping.
Yes. Are these invoices, are these submissions relate to the invoices provided at page 60 of the judge's brief?
Yes.
Please tell my lord who has submitted these GST invoices in the GST portal.
Transit Services Limited.
Yes. Please tell my lord how did the plaintiff came in possession of this document appearing at page 61 to 67?
Online downloaded.
Please tell my lord who has downloaded the same.
By your company accountant.
Are you in a position to identify under whose instructions were these documents downloaded?
Under my instruction.
Are the printouts of the documents same as maintained online in the GST portal?
Yes, it's same.
Lord, may this document be tendered.
J. Yes, next.
Shown PD12 appearing at pages 68 to 81 of the judge's brief of document. Please tell my lord what are these documents?
These are the emails exchanged between the parties, Transif and Progreder.
Are you in a position to identify who has sent the emails to whom?
Yeah, this particular email has been sent by Mr. Akash Bansal.
Has been sent by Mr. Akash Bansal
To the company director, Mr. Tajveer. Mr. Tajveer. Tejveer. Teejveer.
By the term company, whom do you imply?
Transfer Services.
Yes. Are you in a position to tell my lord what were the basis of the emails written from appearing at pages 68 to 81?
These are all the emails which has been sent for the recovery of our containers as well as the money due amount which we are
containers and the due money which is
these
required to
rental
be-
dues. Rental dues.
Are you in a position to tell my lord what is the timeline of the emails appearing at pages 68 to 81?
It's December 21st till December 18, 2021. 18th December 2021.
Please tell my lord, how did the plaintiff came in possession of these emails?
Till November 24th November 2000.
Madam,
she's still answering.
Earlier answer is not completed. First was, it starts from December 2018. 21st December 2018. Last one. Not timeline. What was the period?
Period of it.
Till March 2022.
Now, when they started and what is the first date of the email and what was the last date of the email?
First date is December 18, 2021. Till March 2022. 22.
22.
March 2022.
Done? Please, बोलो दिन of these emails.
This has been provided me by our team from time to time.
Who has taken the printouts of these emails?
Myself.
Are the printouts of the email same as is being maintained online?
Yes, it has been. It is same.
Let me this be marked as an X.
J.
J.
Exhibit key. Yes, next 68.
Shown originals of documents, copies of which are appearing at pages 82 to 212. 212. Please tell my lord, what are these documents?
These are all invoices.
Please tell my lord, these invoices are raised upon whom by whom?
These invoices are raised by Transafe to Probate Shipping Private Limited.
Please tell my lord, what was the basis of raising these invoices upon the defendant?
These are the lease rental bills.
Who has prepared these invoices on behalf of the plaintiff?
By our company accountant.
Have these invoices been served upon the defendant?
Yes, it has been served.
Please tell my lord, what was the mode of service of these invoices to the defendant?
By mail as well as by hand.
Is there an endorsement? Sir, since you have deposed that the invoices have been served, through hand, is there an endorsement on the invoices regarding the same?
Yes.
How did the plaintiff came in possession of these original invoices?
After serving them, there were two copies. One was given to the company, that is Probate. The other one, endorsement copy, we keep for record.
Please tell my lord, these invoices pertains from which period to which period?
Date wise সাজানো আছে? 31st March 2020 to 30th April 2023.
Are these invoices GST complied?
Yes, it has been complied.
My lord, may the originals be tendered, my lord, and marked as exhibit.
Exhibit L.
Mrs. Sen, on the last occasion, you had submitted. Okay, judges briefed into. you had submitted as proprietor that a copy of the agreement, a copy of the agreement was kept by the plaintiff in its records. A copy of the container agreement dated 1st June 2018 was kept by the plaintiff in its records. Are you in a position to tell my lord from where did the plaintiff obtain the copy of the container lease agreement?
It is the Xerox copy of the original. Mr. Vishwanath Mungekar, who signed on behalf of our company, Xerox the document and kept it in his possession. And the same has been maintained in our record, company's record.
Yes. Has the plaintiff initiated any step in procuring the original of this document, being PD3?
Yes, on advice of my advocate, I have instructed her to send a notice to the defendant to produce the original before court.
Shown a document. Is this the email you have been referring to?
Yes, this is the email.
Please tell my lord the date of this email.
24th February 2025.
Please tell my lord what was asked upon which document was called upon to produce?
It is the notice to produce the lease rental agreement.
How this evidence will go? It is not in the pleading.
Lord, just to circum 63 of the Evidence Act, I am asking these questions because it has been marked as a X1, Lord. With
this is not the evidence you led in the pleading. This is not the pleading.
No.
So how you will adduce the evidence?
Lord, a shred of that is there in the affidavit in evidence. A shred of that evidence is there in the affidavit in evidence.
Person cannot be looked into. If
Very
you
well,
are,
Lord. Lord, I'm not tendering that document. I'm just asking her question on that. ठीक है, दे दे. No, it is I'm not tendering.
It is the lease agreement dated 1st June 2018.
How was this notice to produce served upon the defendant?
Through mail.
Is this the email with which the plaintiff used to regularly communicate with the defendant?
Email address.
Please tell the email address provided in the notice. Please tell the email address of the defendant provided in the notice.
Is TEJVEETER KUMAR 66 @gmail.com.
Is this the email with which the plaintiff used to regularly transact with the defendant?
Yes.
Communicate with the defendant?
Yes.
Yes. But so far as this suit is concerned, Lord, it's over. Now, Lord, the next suit is also there at 2 p.m. Lord, in that suit as well, Lord, I have filed an application under Order 11.
Same document.
Lord, some other, more or less the same document, Lord. Lord, today, Lord, I have become wiser. I have come up with the supplementary affidavit on the last occasion, which my Lord said. If my Lord allows, then, Lord, I'll continue. Judges,
Yes, continue.
Yes. Oath Onno chief.
Repeat after me. I solemnly affirm by way of evidence
by way of evidence in this suit,
whatever I will depose,
I shall
speak the truth,
speak the truth,
and no part of it
and no part of it shall be false, and I shall not conceal anything. Shuchishmita Sen.
এটা আপনি রাখুন এক একটা করে ডকুমেন্ট বলে দেবেন যে অরিজিনাল আগে বলবেন
Surajit Sen.
Sen. Page
এটা কি খুলে দেবো
48.
শুধু এটা খুলে দেবো
occupation
Service.
residential address.
4A. J.M. Lane, Kolkata 27.
হ্যাঁ OCD 5 shown an original document. Please tell my lord what is this document?
Affidavit of evidence.
Please tell my lord this is whose affidavit in evidence?
This is my affidavit of evidence.
আমরা কারেক্ট করে দিয়ে দেবো মামলার পর না
ये सेकंड सूट है ना?
হ্যাঁ সিএস নাম্বার ভুল আছে 11 হবে ইনিশিয়াল করে দিন প্লিজ টার্ন টু পেজ 17 of this document and tell my lord who has affirmed this affidavit in evidence.
This is affirmed by myself, Shuchishmita Sen.
Please tell my lord on which date has it been affirmed.
24th February 2025.
Please tell my lord before whom has it been affirmed.
Before the Commissioner of Calcutta High Court.
What do you say regarding the contents of this affidavit?
This is true and correct.
Shown an original document. Please tell my lord what is this document?
This is the certificate under Section 65B of Indian Evidence Act 1872.
Which year suit?
2023 under the Evidence Act, not under the new Evidence Act. Under the
That's why I'm asking.
Please turn to page 4 of this affidavit in evidence and tell my lord who has affirmed this affidavit in evidence.
It's affirmed by myself.
Please tell the date on which this affidavit in evidence.
24th day of February 2025. February.
Right there. Please tell my lord before whom has it been affirmed.
Before the Commissioner of Calcutta High Court.
Supplementary. Shown an original document. Please tell my lord what is this document.
This is supplementary affidavit in evidence.
Please tell my lord who has affirmed this supplementary affidavit in evidence.
This has been affirmed by myself.
Please tell my lord when has it been affirmed.
24th day of February 2025.
Please tell my lord before whom has it been affirmed.
Before the Commissioner of Calcutta High Court.
65 shown an original document. Please tell my lord what is this document.
Supplementary affidavit under Section 65B.
Please tell my lord who has affirmed this affidavit.
This has been affirmed by myself.
Please tell my lord before whom has it been affirmed.
Before the Commissioner of Calcutta High Court.
Please tell my lord when has this been affirmed.
24th day of February 2025.
What do you say regarding the contents of this affidavit? These affidavits. Regarding the contents of these affidavits.
This is for the electronic mails. Contents are true and correct.
Shown an original document, copy of which is appearing at page 2 of the judge's brief of document. Please tell my lord what is this document.
This is the board resolution.
Please tell my lord the date of the board resolution.
20th day of July 2021.
Please tell my lord who has issued this board resolution and in whose favor.
This has been issued by Ashish Mathur, director of our company, in my favor.
Please tell my lord for what purpose has this is this board resolution issued in your favor.
To look after the legal applications, legal matters pending before the court, to file supplementary affidavit, etc.
Are you in a position to identify the signature of Mr. Mathur as deposed by you?
Yes, he is the director and my reporting boss. I know his signature.
My reporting boss. So I know his.
How are you aware of his signature?
He is my reporting boss. He signs before me. He signed before me.
Already stated. Please tell my lord, how did you get in possession of this document?
This has been handed over to me by hand.
Are you in a position to identify where was it handed over?
It has been handed over at Delhi.
Necessary.
Very well. Well, may this be marked as an exhibit. Exhibit A. Shown page 1 of the judge's brief of document. Please tell my lord, what is this document? Please tell my lord, what is this document?
Page 1.
Page 1.
Eta hobe.
PD1, page 1.
This is a printout of MCA, Company Master Data.
Please tell my lord, whose master data, whose printout of master data is this?
Transit Services Limited.
Please tell my lord the date on which this printout was taken.
1st December 2023.
Are you in a position to tell my lord who has taken the printout of this document?
Myself.
Is the printout of the document same
Yes.
with the data maintained online?
Yes.
Please tell my lord from which website was this printout taken?
www.mca.gov.in.
Lord, may this be marked as
Exhibit B.
Exhibit B. Shown page 3 being PD3. Please tell my lord, what is this document?
This is also a copy of master data, company master data.
Please tell my lord, whose company master data is this?
SM Container Lines Private Limited.
Please tell my lord, when was this printout taken?
January 2023.
Yes. Please tell my lord, who has taken the printout of this document?
Myself.
Please tell my lord, is the printout of the data same as maintained online?
Yes.
Lord, may this be marked.
Exhibit C.
Agreement is the original, na? Shown. Okay. Shown PD4 appearing at page 14 to 12 of the judge's brief of document. Please tell my lord, what is this document?
This is a container lease agreement between Transit Services and SM Container Lines Private Limited.
Are you?
Container lease agreement executed between Transit Services Limited and SM Container Lines Private Limited.
Please tell my lord the date of this container lease agreement.
It's 11th day of December 2017.
Please turn to page 12 and tell my lord, are you in a position to identify the signatures appearing thereat?
I know the signature of Vishwanath Mungekar.
Please tell my lord who is Mr. Vishwanath Mungekar.
He was deputed in Mumbai and used to look after the operations of lease rental agreement.
Are you in a position to tell my lord on whose behalf was Mr. Mungekar operating the lease container services?
For Transit Services Limited.
Yes. Please tell my lord, how did the plaintiff came in possession of this document?
This lease agreement was signed at Mumbai and Mr. Mungekar took a printout, a Xerox copy of the same and handed in the possession of the company.
Is it your evidence that Mr. Mungekar had obtained the copy of this agreement from the original of the agreement signed by the parties?
Yes, he did so because it was in our record.
Has the plaintiff taken any step to call for the original of this document?
Yes, on the advice of my advocate, I told her to send a mail. A notice has been issued through mail to produce the original before court.
Yes. Are you in a position to tell my lord the date of the email?
24th February 2025.
Yes. Was that email sent? Sorry. Can you please tell my lord how was that notice served upon the defendant?
Through mail.
Through mail. Very well. The tender only to marked with identification. Lord, may this be marked subject to for identification.
Yeah, yes.
Container agreement, my lord. The copy of which I am producing.
Expired.
Expired.
For identification, page number 4.
4 to 12. 4 to 12.
Supplementary judges brief of documents.
No, judges brief. Judges brief.
Of documents.
Yes, next.
Shown pages 13 to 14 of the judge's brief of document. Please tell my lord, what is this document?
This is the account details maintained by our account department. Here it is shown the party name, the bill number, the bill date, bill amount, amount received and the due amount.
Please tell my lord, what is the sum which the plaintiff is claiming as per this chart?
87 lakh 21,000 and 49 rupees.
Please tell my lord, what is the period in which for which this computation has been derived at?
There are bills of 2019, 20 as well as 22, 21, 22.
Who has prepared these charts?
This chart has been prepared by my account department.
From please tell my lord, from where were these particulars entered in this particular chart?
By your company record, account team record.
What do you say regarding the contents of these charts appearing at page 13 to 14?
These are true and correct.
Yes. Let me this be marked.
Exhibit D. Exhibit
D. Shown PD6 appearing at page 15 to 35 of the judge's brief of document. Please tell my lord, what are these what is this document?
These are the bank statement, HDFC bank statement.
Please tell my lord, in whose account, in whose name is this HDFC bank statement maintained?
Transit Services Limited.
Are you in a position to identify the branch of this particular bank?
Stephen House, BBD Bagh.
Please. Stephen House, BBD Bagh. Please tell my lord the period for which this bank statement has been disclosed.
Is the period from 1st June 2021 to 30th June 2021.
Please tell my lord, why was this particular period only disclosed before this honorable court?
In this period, there was a transaction between Transit Services Limited and the company, SM Container Lines.
Please imply, what do you mean by the word transaction?
Some payment has been received.
Please tell my lord, who has received the payment and from whom?
Transit Services Limited has received the payment from SM Containers Lines Private Limited.
Please tell my lord, how did the plaintiff came in possession of this document?
This is the printout, online printout.
Who has obtained this online printout?
My account department.
Are the printouts of these documents same as it is maintained online with HDFC Bank Limited?
Yes, it is same.
Let me this be marked as an exhibit. Exhibit
E. Yes, next.
Shown PD7 appearing at page 36 to 42. Please tell my lord, what is this document?
Page 36 is showing the due amount with the bill date and the amount received. Page 37 to page 42 is reflecting with the details of the container number.
Please tell my lord, what does the term ILCU under the heading container number imply?
This is the unique code number which has been received by the Bureau International.
Please tell my lord, this symbol ILCU is earmarked to which party?
To Transit Services Limited.
Please tell my lord the list, the number of containers which, as per the chart at page 37 to 42, is in the custody of the defendant.
213 containers.
Are you in a position to provide the start date with which the containers were in the custody of the defendant?
November 22nd, 2018.
Who has prepared these charts?
By our account team.
Under whose instruction?
In my instruction.
What do you say regarding the contents of these charts?
These are true and correct.
But PD8 is section 12A. I'm not exhibiting it.
Exhibit?
Exhibit F.
Huh?
F. It is supplementary. Lord, I'm tendering the supplementary.
Them documents?
No, Lord, the invoices and the emails. Shown page 1 to 4 being PD9 of the supplementary. Please tell my lord what is this document?
These are the total due of lease rental and the list of and the details of the containers. Period has been mentioned with rates.
Please tell my lord where from the plaintiff has provided the rates in the chart.
It is mentioned in our agreement.
Yes. Please tell my lord who has prepared these charts.
This has been prepared by our account department.
Please tell my lord under whose instruction has these been prepared.
It's prepared under my instruction.
What do you say regarding the contents of this chart?
True and correct.
Please tell my lord where from the particulars have been provided in these charts.
It is the record which has been kept in our company. From there it has been prepared.
Yes. Lord, may this be marked as an exhibit. Lord. Exhibit next is.
Yes, next.
Shown pages 5 to 24 of the supplementary judge's brief. Please tell my lord what are these documents?
These are the different emails exchanged between Transit Services Limited and SM Container Lines.
Please tell my lord the period of these emails exchanged between the plaintiff and the defendant.
From July to December 2021.
What were the purport behind issuing these emails by the plaintiff?
These different emails were exchanged between the parties for our lease rental dues and our containers. 212 containers.
Please tell my lord, how did the plaintiff came in possession of these emails?
These are the different emails exchanged between the parties in our company, and this has been provided to me by them.
Who has taken the printout of these emails?
Myself.
Are the printouts same as will appear online,
Yes.
maintained with the email platform?
Yes, it's same.
Lord, may these be tendered collectively. Exhibit H. Collective. Page number 52. shown originals of documents, copies of which are appearing at pages 25 to 230 of the supplementary judge's brief. Please tell my lord, what are these documents?
These are the different invoices raised upon SM containers.
Please tell my lord, what were the nature of invoices raised upon the defendant?
For lease rental agreement.
Please tell my lord, who has prepared these invoices?
By the account department.
Please tell my lord, are these invoices, has the invoices been served upon the defendant?
Yes, it has been served.
Please tell my lord the mode of service upon the
hand
defendant.
And some through hand and some by mails.
Since you have deposed that the invoices were served through hand, will the endorsement appear on each of the invoices?
Yes, it is there in each of the invoices.
Please tell my lord the period from which to which these invoices have been raised and served upon the defendant. Dates. The invoices have been prepared and served upon the defendant. application করতে হবে এবার বলবো
1st March 2019 to 1st March 2021.
Lord, may the originals be tendered, Lord. Lord,
Debate.
Collectively. Lord, the chief is over.
That's all.
Lord, and this application is required to be disposed of. Lord, one more thing, Lord, we have found out that there is a demand notice, which we have received, the original demand notice, which we have submitted to the defendant. That's not a part of the record. That I'll have to file a separate application. But for that, your lordship may kindly have to fix another date, Lord. Only 10 minutes, my lord, any day your lordship fixes.
Item number 4. Separate. Item number 4. Plaintiff is present. Examination chief resumed today. During our examination, आज कौन सा पहला वाला में exhibit? During our examination, exhibit. H2 have been exhibited. Full stop. Examination chief is concluded. Witness is discharged. Full stop. Counsel for the plaintiff. In both, my lord. Counsel for the plaintiff. Praise for time for taking further risk.
No. I'm sorry, my lord, for further only in this matter. In the other matter, other everything.
Counsel for the plaintiff submit that or no evidence for
Lord,
that.
no evidence.
Counsel for the plaintiff submit that he will not adduce any further evidence. Accordingly, evidence on behalf of the plaintiff is closed. Will fix for argument. Let the matter appear on 11th March 2025 for argument. Yes. Next.
7th.
Where is your application? So bring for the plaintiff. Plaintiff has filed an application. For plaintiff filed an application being GACOM 2 of 2025. Praying for you to disclose additional documents. That is, what are the documents?
Lord, the documents are mentioned at paragraph number 6, my lord. The documents are, my lord, twofolds. One is that chart containing ILCU number. Second documents are the emails. And the third set are the original invoices.
Where you mentioned
Lord,
details? Printed disclose various documents. Where is the document you disclose? Where you mention? You're not given the list.
Lord, we have given the.
Where? क्या बोला? Disclosed container list. Containers list.
Page 11 to
document that is
14.
container list, comma, email reflecting communications and copies of the invoices. Full stop. Copies of the invoice. Full stop. Number next. Counsel for the plaintiff submitted as the documents were not in possession of the plaintiff, comma, plaintiff, and thus the plaintiff could not disclose the said documents at the time of filing of the suit. Full stop. Counsel for the plaintiff submitted at the time of preparing the evidence of the plaintiff's witness number 1, comma, plaintiff came to know about the said document, came to know that the said documents are not disclosed. Accordingly, the plaintiff has filed the present application praying for leave to disclose the said document. Number next. Counsel for the plaintiff submitted the documents which the plaintiff intend to disclose, comma, the same are very much necessary for the purpose of adjudication of the instant suit, and unless and until the plaintiff is not allowed to disclose the said document, comma, the plaintiff will suffer irreparable loss and injury. Had the learned counsel for the plaintiff peruse the documents which the plaintiff intend to rely upon. Full stop. This court find that it is a specific case of the plaintiff that the said documents were not in the hand of the plaintiff at the time of filing of the suit, and subsequently when the plaintiff has prepared the examination chief affidavit of evidence of the plaintiff witness, comma, plaintiff came to know about the said document. Consider the submission. This court find that sufficient cause has been shown by the plaintiff for not disclosing the said document at the time of filing of the suit. Accordingly, prayer
A to C.
A to C of the master summon is allowed. GA Com 2 of 2025 is disposed of. Full stop. Number next. The plaintiff has filed examination affidavit of evidence and supplementary list of documents. Let the same be kept with the record. Full stop. Consider the plaintiff has examined. Plaintiff is present during her examination. Documents being exhibit A to R have been exhibited. Full stop. Close.
A to I, my lord, not R. A to I.
A to I.
Closed.
Closed.
Only, my lord, that document I have to disclose. I have to
What
file.
do you want?
That, my legal. Your lordship legally defers it. In the meantime, I shall come.
I am closing it. How it can be deferred? There is no application today.
There is no application.
Full
I'll have
stop.
to file.
क्या बोला? Full stop. Counsel for the evidence is counsel for the print evidence is chief is completed. Witness is discharged. Full counsel for the plaintiff prays for time for taking further steps. According case adjourned. Let the matter appear on 11th March.
Lord, 11th March under the heading witness action, my lord. Under the heading witness action, I'll have to tender one more letter, my lord.
First, you have to come with an application.
I will come. That's very well, my lord. In the meantime, I shall come. Extremely great.
Next.
This matter was mentioned today morning, my lord.
Yes.
My lord, there are certain original documents which are still missing. Well, I'll just indicate what they are, my lord. They're all tendered before the criminal court where a pending criminal proceeding is there. We've already applied for the certificate copy. We still not received it. My lord, will kindly give us some time. We'll bring the affidavit is ready. Otherwise, my lord, it's Metropolitan Magistrates Court, my lord. 14th Metropolitan Magistrates Court. We've already applied for the certificate copy. It's not arrived.
Transitions appearing for the plaintiff. The case is fixed today for witness action. Full counsel for the plaintiff submit that the plaintiff is relying over certain documents which are the exhibit in the criminal proceedings. Accordingly, the plaintiff has applied for the certified copy of the said document, but the plaintiff could not get the said document. In view of the above, counsel for the plaintiff prays for adjournment. consider the submission made by the counsel for the plaintiff. The case is adjourned. So
We'll keep it towards the end of March whenever Malod's diary
let
permits.
the
my lord,
matter appear. Give the April.
because it'll be witness action.
Let the matter appear on 17th April at 3 p.m.
Obliged.
for witness action. Yes, next.
Item number 16.
My lord, I appear for the defendant in this matter.
I'm extremely sorry for yesterday, my lord. Extremely sorry, my lord. We were not there, my lord. Extremely sorry, my lord.
The plaintiff is making submissions in the judgment upon admission application, my lord.
Reply.
Well, my application is gone, my lord. GA3.
GA3 is?
On my application under order 12, rule 6 of the code, my lord. Anyone takes the GA1, so I'll just use the GA1 at first, my lord.
GA1 is?
No, GA1 was for injunction application, and not GA3 I'll be placing, my lord, first, my lord. Can anyone take GA3, my lord?
Yes.
Can anyone takes the application? The required reason is that, my lord, we have made many statements, my lord. Now, my lord, many statements are just, my lord, denied, just mere denial. And, my lord, in my statements, I've made specific governments that this much, the 2.5 crores rupees has been paid to them. And just mere denial. I'll just show the paragraphs, my lord, which will be relying upon, my lord. Lord, kindly, my lord, takes, my lord, the plaint, my lord. Here, my lord, paragraph 1 and 2. Sorry, my lord, the application, my lord.
The order 12, rule 6.
Order 12, rule 6, my lord. My lord, I pleaded, my lord, the suit, my lord.
Your suit for recovery of money.
The suit for recovery of money. My lord, 2.5 crores, my lord. Along with interest, my lord. My lord, paragraph 5.
Of your application.
My application, my lord. Why I'm saying is an admission, the whole facts that there was a mortgage deed, unregistered mortgage deed, my lord, agreement. Thereafter, subsequent, my lord, another supplemental agreement. Thereafter, registered deed from where the money was transacted was done, my lord. These facts and the money was received by the plaintiff, by the defendant, my lord, from the plaintiff, my lord, has been categorically admitted by them in an affidavit filed in court. That's the reason I want to show, my lord, what pleadings are there, my lord, first, my lord. Kindly, my lord, takes paragraph 2, 3, my lord, and 4, my lord, 4. The defendant requested for a loan of rupees 2.5 crores, stated that she would repay back the said loan within interest after 2 years period of time. So it was agreed on online credit.
So this is our case.
Yes, my lord. Thereafter, my lord, I'm going to just show, my lord, the pleadings, my lord, so that, my lord, the opposition also says the same pleadings, my lord, are there. Paragraph 4. Page 4, paragraph 5. I have pleaded the terms of the agreement, and thereafter, my lord, I pleaded, my lord, the MOU dated 15th May 2014, and thereafter, the rights which occurred. Paragraph 6. In finalizing the terms of condition of the agreement between the parties, the plaintiff and the defendant originally entered into an agreement dated February 17, 2016, page 6,
yes,
which more or less laid down the basic understanding by and between the parties, as already herein stated above. Thereafter, my lord, pleaded the supplementary agreement of 2nd March 2016. And, my lord, up to obtaining legal advice, parties were aware of such agreement and aforesaid by which the parties wanted to create a record of factored loan. Paragraph 9, my lord, the agreement of March 17, 2016, which is a registered deed. Lord, kindly, my lord, takes the registered deed once. The registered deed is at page 47. my lord, page 52, paragraph H, and thereafter page 53 states about the 2.5 crores and the 2 years time.
Page
54.
Page
Lord,
53.
53 also, my lord, 53, sorry, 53, I'm so sorry, 53, my lord.
2 years.
53, yes, my lord. The first 5 or 6 lines, my lord. 2 years fails to repay. 54. Not troubling, my lord, the same amount is given here every time the 2 years time is required to be paid. And thereafter, my lord, what goods or assets were charged as page 57. And then page 57, my lord, clause 1, clause 2, page 58, clause 3. He stated what happens if there is a default of 2 consecutive months. And then, my lord, page 64, 65, my lord, the receipt of the 2.50 crores, my lord.
Reflect the bank statement. Reflect reverse bank statement.
Or kindly, my lord, takes, my lord, page 65.
Yes.
G2 reflected.
Page 65, my lord, 2.50 crores, and my lord, the mood. My lord, this payment will would reflect, my lord, in a bank statement which we have annexed to their application GA2, page 11, in our affidavit in reply, affidavit in opposition, my lord.
GA2.
GA2, page 11. আচ্ছা আমরা দেখুন কপি দিছিলাম অ্যাফিডেভিট দিছিলাম একটা 15 ফেব্রুয়ারি 2023 এর অ্যাফিডেভিট আছে একটা হ্যাঁ GA2 এটা 15 ফেব্রুয়ারি না অ্যাফিডেভিট ডেটটা না GA2 না এটা না এটা হচ্ছে এটা দেখুন অপোজিশন আছে একটা হ্যাঁ 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 এটাই This is an affidavit dated 15th of February 2023. My affidavit, my lord. Page 11.
Yes.
My lord, I have given the dates and the highlighted portion, my lord, are my lord, the transaction details, my lord.
Yes.
And my lord, kindly, my lord, takes the the bank account statement number, but it's Mahadev Real Pro, the plaintiff, my lord. So, my lord, it's an admitted fact that this amount of money has been received by the defendant, one, from the plaintiff, my lord.
Yes.
Now, my lord, kindly, my lord, takes, my lord, to acknowledge the debt, my lord, and to secure us, my lord, on July 1st, 2016, page, my lord, 128.
Yes.
Page 120 of the application. There's a letter dated July 1, 2016. This letter was issued by the defendant number 1. Defendant number 1. My lord, giving us, my lord, 23 checks, my lord. Post dated 23 checks. 23, my lord, checks, my lord.
Yes.
For a total amount of 2.7 crores, which includes the interest portion even, my lord.
Yes.
When I've calculated this 2.70 crores towards the interest portion even, my lord. Interest payment of rupees 2.5 crores against the mortgage loan. This document, as well as the checks, are admitted, my lord. Now, my lord, kindly, my lord, takes, my lord. The 23 PDCs, page 134 to 143 are the PDCs, my lord. 134, my lord. $143.
134.
To 143, 23 PDC checks, my lord. Post-dated checks, my lord.
134 to
134 to 143.
dishonored. These are dishonored.
Yes, my lord, all dishonored checks. No, these checks were dishonored, my lord. Yes, my lord.
Yes.
134. Huh. Now, my lord, after that, my lord, issuance dishonored due to, my lord, different name, my lord. The different name, my lord, I have already explained, my lord. I will be explaining again, my lord, why the different name was there, my lord. Now, my lord, when I'll be dealing with the opposition, my lord, I'll be explaining, my lord, why, my lord. That's the defense they had taken. Issued a thereafter, my lord, we had issued a recalling notice, my lord. On August
No,
3rd.
written on the not due to change of name.
Yes, my lord, change of name.
Written following result.
The Mahadeva real estate, what they
Account close.
I'm so
Kindly come
grateful.
to the 134.
Yes, my lord.
134, 135. Account closed.
I'm so grateful, my lord. I am so grateful. I should have indicated, my lord. Account close. I'm so grateful.
Yes.
133 payment name differs. 134 is account closed, my lord. 134, 135 is account. I'm so grateful, my lord. These are the two checks, my lord, which is found in, my lord, page 123. The list of checks are there. My lord, from 128, the list of checks are there. My lord, the last two checks, my lord, of 66 lakhs each, my lord. Which are the two checks, my lord? 60 lakhs, my lord. 60 lakhs, my lord. These are the two checks, my lord. Which, my lord, are the account close checks, my lord. Page 128, last two checks, my lord. Can you, my lord, see, my lord? 129, my lord. 129, the last two, my lord. 1/5/2018.
120. 6 lakhs, 6 lakhs.
My lord, 134, I think the same document has been annexed again, my lord. My lord, it's account closed. 134 is account closed, my lord.
Account close. 130 name defer.
130 will come, my lord. 130, I'm saying, my lord. Now, my lord, what happened is that, my lord, after that, my lord, we issued a demand notice to them. My lord, page 125, my lord.
Yes.
The page 125, we demand the sum.
Yes.
Paragraph 3, 126, paragraph 3, my lord, should be returned within 2 years' time with an interest, my lord. Clause 2 of the mortgagees, borrower were required to pay the financial charges interest at the rate of 4% on the mortgage amount, and for such clause ought to have been credited by us, returned by 2 months' time, my lord. Within a period of 2 days from the date of execution of the deed of mortgage, clause 3. And thereafter, my lord, the particulars of payment. And thereafter, my lord, the stamp, Indian stamp post, my lord, saying that it has been issued to them. But there is no reply to this mail, my lord. Their contention is they have not received it, my lord. However, my lord, if my lord, the General Clauses Act has taken, my lord, if it is in the right address, my lord, then, my lord, it is, my lord, considered to be within 48 hours, considered to be.
No track report.
No, my lord, 2080 was not expected, my lord, they are going to, my lord, the different advocates said, my lord, not expected that, my lord, they are going to deny this letter, my lord. Because, my lord, the track Indian post code is here, my lord. But now, my lord, we cannot get after, my lord, a certain time, my lord, we cannot get the track report, my lord. So, my lord, we have to rely upon this, my lord. My lord, be that as it may, my lord, this notice, my lord, has not been denied. Rather, my lord, no reply is there. I'm not sure denied, no reply is there. Thereafter, my lord, what they did was that they issued fresh checks, my lord, which is as page 130. 130. My lord, two fresh checks were issued. Page 130.
Yes. 131 check. 50 lakhs.
50 lakhs, my lord, 50 lakhs, my lord. Thereafter, again, my lord, at page 132.
131.
No, 131, my lord, I'm not saying, my lord, because I think it's the same check, my lord.
Same
I,
check.
I think it's set up,
582.
Xerox copy has been put in again. So, my lord, 132, my lord.
132.
Is there another different, my lord? 50 lakhs, my lord.
Yes.
Again, my lord, a payment done, my lord, of 1 crore, my lord, paid, my lord. Issued to us. However, my lord, the name, payee name differs.
Yes.
Now, my lord, page 146, thereafter, again, I issued a demand notice.
Yes. Yes. So what is the contents? What they said, they have not paid them on date.
My lord, again, my lord, no reply, my lord. Page 146, I'm showing what happens, my lord. 146, my lord.
Reply.
Page 146, my lord, this is the notice. My lord, page 156, addressee moved.
Who has issued the notice?
My lord, the advocate of
No,
plaintiff.
this plaintiff.
Plaintiff notice, my lord. 146. 23/5/2022 notice.
Yes.
We're calling upon them to make payment within 7 days' time with the interest portion amount. My lord, addressee moved from there. Page. And my lord, kindly, my lord, one pull the junior. My lord, here, my lord, I have specifically stated about the mistake in the name, which is there. However, I also stated that the correct PAN number was there.
Yes.
And the secret details were there. I has already dealt with it before. Both part of your mistake has been mentioned as Mahadeva Real Estate Company Limited. The PAN number and all other details of the signatory of the fourth part is that of my client.
Yes.
That fact was always known and admitted by all the concerns. As such, those checks were presented with dishonored endorsement, payee name deferred. We've explained, my lord, that there was a error, my lord, on both of our part, and this error was known to both the plaintiff as well as the defendant, and hence, my lord, they cannot take good of the wrong. The reason is because, my lord, they have received this consideration. There's no denial that they have not received the consideration, my lord. Now, my lord, kindly, my lord, takes, my lord. I showed the, my lord, the postal receipt, my lord. They say that, my lord, the item returned addressee moved, my lord. Now, my lord, kindly takes page 170 to the plane, what we have prayed for. Computation to no, page 189 is the relief or the claims, my lord. Page 189 is my claim. A decree for a sum of rupees 9 crores as paid in paragraph 19.
Yes.
The interest portion. And my lord, at page 145, my lord, a computation is stated with regard to the interest portion, how the calculation has been made. And my lord, in the plaint also, we have made the pleadings of typographical error, my lord. You know, that is not important here. And the calculation paragraph 19, we have pleaded, my lord. Now, my lord, kindly, my lord, takes, my lord. Thereafter, my lord, an injunction order. No, thereafter, my lord, we file an interlocutory application of injunction, my lord. My lord, GA1. My lord, in that GA1, an order was passed by your lordship, my lord, 29 September 2022. देवेन एक order copy लोग पूरा टाइम दिन ना क्या कहते हो देखो My lord was pleased to grant orders in terms of prayer. E and H.
Yes.
Page 235, I think, my lord, the order copies are there. I'm sorry, my lord. Page 235 of the application, we also annex the orders. Page 236, 235. Prayer E and H was granted.
Yes.
Thereafter, the interim order was stood extended. Now, my lord, on December 21, 2022, the defendants appear, my lord. They took out an application for vacating the GA2, took out an application for vacating the interim order. Now, my lord, they have also, my lord, filed an affidavit in opposition to my injunction application GA1. My lord shall find it at page 247. File,
247.
247.
Yes. Affidavit in opposition.
My lord.
Yes.
Well, kinematics 247, the reason the letterhead is important. Why, my lord? May I read out, my lord? 247 is letterhead, my lord, of the advocate of the defendant number 1. Please find enclosed herewith the copy of the affidavit in opposition filed on behalf of our client above named in the caption matter. So, my lord, an opposition filed before this honorable court, my lord, by the defendant number 1, as it says, my lord. Now, my lord, 248, it starts, my lord. Paragraph 1, Sushila Jain, defendant number 1, respondent number 1, affirms. Paragraph 2, a copy of the application being GA number 1, 2022, purportedly affirmed by such and such, on 21st day, being served upon me. I have read the same, understood the meaning, contents, and purport thereof. So, my lord, she knows what she is filing. She has read the GA1 application. Thereafter, my lord, she is filing this affidavit, my lord. Save and what are expressly admitted herein below, the statements, save and what are expressly admitted herein below, the statements or allegation in the petition are denied in this. So, whatever is admitted are admitted by her. Before dealing with the allegations and the event contained in said application, it as follows: the application is misconceived, such and such. I'm not troubling, my lord. Now, my lord, kinematics, paragraph 5, 251. I shall now proceed to categorically state the actual facts and circumstances of the event that occurred. Paragraph 1, she says about the grave leave to lie upon GA2, and thereafter B. The answering respondent, for the purpose of availing a loan of rupees 2 crores 50 lakhs, executed a deed of mortgage dated February 17, 2016 in favor of the plaintiff company herein, who was represented by one Suresh Kumar Agarwal. The said loan was agreed to be an online credit loan, agreed to an advance given for coordination between the petition and the management. And this one, it become pertinent to mention respondent number 2 stood as the guarantor. Respondent number 3 was the confirming party to such deed of mortgage. They are answering different grave leaves, or not. Thereafter, she says about the supplementary agreement, paragraph C. Thereafter, a supplementary agreement was entered into between the self-same parties, wherein it was agreed that the answering respondent shall pay 9% of 2.2 of 2,25,000, the total finance charge interest for a year. The relevant clauses of the supplementary affidavits are as follows. These set out the clauses. Then 253. Subsequent, as per legal advice, the parties collated all the terms and conditions as contained in the deed of mortgage dated February 17, 2016 and the supplement agreement dated March 2, 2016 and executed a deed registered mortgage dated March 17, 2016. This is thereafter. The answering respondent number handed over the checks wide letter dated July 1, 2016, my lord. That is the letter, my lord, at page, my lord, 128, which I was showing, my lord.
Yes.
So, my lord, the acknowledgement of the fact that they had issued the letter to the plaintiff.
Yes.
They had issued the checks to the plaintiff. Acknowledgement of the deed, of the first deed, the supplemental deed, and the registered mortgage deed. And also the fact that one of the checks, my lord. Now, my lord, what they are thereafter, my lord, kindly, my lord, takes. My lord, G, the covering letter dated 1st July 2016 issued by the defendant number 1 is not in favor of the, that means again the defense they are taking. And my lord, kindly, my lord, takes thereafter one more paragraph. Yes. 251 paragraph Z. 259 paragraph Z, my lord.
Yes.
The answering response number 1, however, states that in terms of the agreement, the plaintiff petitioner have paid a sum of rupees 2.50 crores to the defendants who are answering respondent by transferring the said amount in the account of answering defendant against the security in the nature of equity shares held by defendant number 1, answering defendant 3, answering number 4. Well, this is a clear admission of the fact that the defendant number 1 has received the, my lord, what has been admitted here by them. My whole case, my lord, is of that, my lord, there are 3 agreements.
Yes.
They had issued, my lord, PDCs to against for that agreement. Subsequent thereafter, my lord, they have taken money from that and given the PDCs. Here, my lord, the agreements, the 3 agreements, the 17th February agreement, the supplemental agreement, as well as the March agreement, the main agreement, all 3 has been acknowledged by them. Further to the fact, they have also acknowledged the letter which they have issued, which is the covering letter of all these checks which they have issued to us. And also, my lord, they have acknowledged the fact in an affidavit stating, my lord, the amount they have paid, my lord, the 2.50 crores, my lord, they have received from the plaintiff, my lord. My lord, kindly, my lord, takes, my lord, the affirmation once, my lord. 265, my lord. My lord, all the statements made in paragraph 1 to 18 are true to my knowledge, and rest are my humble submissions before this honorable court. Now, my lord, kindly sees that it is an affirmed affidavit, affirmed before the commissioner of this honorable court. 3rd April 2023, my lord, they come and affirm this. It is not that she was not aware, she knew very well where she was coming, she signed it, my lord. Now, my lord, kindly, my lord, takes their opposition once, my lord. The defense, my lord, which they try to set up, my lord. So the first defense they take in the opposition.
The opposition is the page 244.
No, that's the opposition in GA1. GA1. They had filed.
Okay.
No, my lord, I'm just, my lord, I'll trouble, my lord, once, my lord. What they have done, my lord. Subsequent thereto, my lord, I'll just show my lord the GA1's, my lord. My lord, they came up with a story, my lord, saying that no, this affidavit has been wrongly filed by us. This is a draft affidavit. It's a draft affidavit. It's not wanted to be filed. So we are withdrawing it. My lord, they tried to present the case, my lord, before this honorable court on 24th April 2023. My lord, kindly, my lord, takes page 267. It's an order, my lord.
267 of GA3?
Of the GA3, my lord. The last 2 pages, my lord.
Yes.
There is an utter confusion. I'm sorry, my lord.
Yes.
Order dated April 24, 2023, my lord. My lord, the defendant number 1 appears, my lord. There is an utter confusion in this matter created by the defendant number 1 while filing the affidavit in opposition to this application. Initially, an affidavit affirmed on 3rd April 2023, which my lord has shown 247, my lord, was served upon the plaintiff. On the basis thereof, the plaintiff obtained the direction to filing a reply thereto. The affidavit on reply was affirmed on April 12, 2023. On the same day, the plaintiff petitioner received an electronic mail On 12th April, my lord, received electronic mail from the defendant saying that the affidavit opposition affirmed on April 3, 2023 was served on the plaintiff was by a mistake and should be discarded. Defendant number 1 has now affirmed another affidavit on April 19, 2023. The affidavit filed in the court today is taken on record. Thereafter, without prejudice to the rights and contention of the plaintiff, if any, in respect of an admission, if any admission said to have been made in the first affidavit affirmed on April 2023, the plaintiff shall be at liberty to use that if in reply to the opposition. So, my lord, we had the liberty to use the admissions made in the said affidavit, my lord, at all time. And my lord, their statement that the affidavit has been withdrawn, or my lord, they have been allowed to withdraw the affidavit, well, it's completely false, my lord. Now, my lord, kindly, my lord, takes, my lord, the opposition, my lord, to this GA3, my lord. And what defense they have taken, my lord, to my application, my lord. And my lord, also, my lord, I'm sorry, my lord, before my trouble, my lord, but I want to, my lord, take my lord to once, my lord, to the opposition, my lord, that affirmed to opposition 247. As I want to show, my lord, how they have dealt with my pleadings, my lord, there. And in 247, my lord, the affidavit, there also, my lord, in the affidavits, my lord, there is no statement or denying any statement, my lord. My lord, look, I'm just saying, my lord, there is no denial of the statement, my lord, in the affidavit affirmed that they have not received money from me. Or, my lord, only, my lord, defense, my lord, now which they take. First, with regard to the affidavit, affirmed affidavit, is that, my lord, kindly, my lord, takes their affidavit in opposition, my lord, once, my lord. Paragraph 3, my lord, they make a statement that there has been no admission of facts in any pleadings before this honorable court, which would warrant passing any decree. I don't know how they made. Additional, my lord, there is no admission made by the deponent anywhere agreeing to make payment to the plaintiff, and the question of passing a decree of such and such does not arise. Well, affidavit in directions was passed on GA1 by electronic mail dated April 12, when the defendant number 1 to the advocates informed the plaintiff that she has inadvertently served an unsettled draft. Look, kindly, my lord, takes page 4, paragraph 4B. By electronic mail such and such, defendant number 1 through their advocate informed that plaintiff that she had inadvertently served an unsettled draft. An affidavit which has been affirmed by this honorable court has been filed before this honorable court. She comes up and says it's an unsettled draft which she intend to withdraw. How bad can it be? The plaintiff was also requested not to proceed with the said affidavit in opposition by filing his reply until a final copy of the affidavit was served upon the petition. The electronic mail such and such. Another day, our reply, affidavit in reply to the opposition was being filed. They sent an electronic mail, said, do not file it. It is a unsettled draft opposition. Paragraph C, my lord. Now, my lord, kindly, my lord, takes, my lord, the paragraph D. What this say, my lord.
Yes.
The advocate of the defendant number 1, thereafter, on 19th April, served a final draft of edition dealing with all the paragraphs of the application, being GA1 of 2022, denying and resulting in allegations. My lord. Here also, my lord, they say that all the paragraphs was not dealt in the previous affidavit, which is also a completely false statement, because, my lord, from the affidavit at page 247, my lord, it can be seen that all the paragraphs of the application GA1 has been dealt with by them, and also, my lord, statements made, my lord. It is not that anyone knew. Their application has been dragging thereafter into the agreement. Now, my lord, thereafter they again come up with the story of with the different name.
Yes.
They have not entered into an agreement with the plaintiff. The same story, my lord, that's already known, my lord. The documents having not been executed properly, therefore does not binding upon the defendant. The document was prepared by the concerned person representing. Now, my lord, with regard to the PAN number, which is of the defendant, my lord, which he, the defendant number 1 says, my lord, that they assumed that the PAN number was different or the PAN number was not of the plaintiff, my lord. Page 9 and 10. The last page 10, the first portion, my lord. In concern advocate, this one, that such name is apparent from the recital. It was assumed that the PAN card number belongs to Mahadev Real Estate. My lord, the PAN card number, my lord, shows, my lord, that the name of the plaintiff is there and not Mahadev Real Estate, my lord. Mahadev Real Estate, sorry, my lord. और कुछ है इसमें दिखाने के लिए?
Yes.
Only one paragraph I want to show, my lord, how blatant lie, my lord, they have made. Page 11, my lord. While dealing with my paragraph 11, where I have made a statement that the money has been received by the defendant number 1 from the plaintiff, my lord. Now they make a statement. It is denied that the plaintiff petitioner has lent the sum mentioned in the paragraph under reference to the defendant number 1 or the respondent number 1 in the manner indicated as alleged at all. They do not say, they do not go and to say that I have not received it. It's not in the same manner. They do not say, my lord, I have not received the sum. So, my lord, there's an admission in a fact, in a way. Kindly, my lord, takes page 11 once, my lord. The opposition.
Yes.
Page 11, my lord. My lord, it is denied that the plaintiff petitioner had lent, my lord, the first 4 lines, my lord.
Yes.
It's denied that the plaintiff petitioner had lent the sum mentioned in the paragraphs under reference to defendant number 1 or respondent number 1 in the manner indicated as alleged at all. In the manner indicated, my lord. There is no saying, my lord, they do not say, they do not stop to say here that no sum was paid or received by the defendant or by the defendant number 1 from the plaintiff. In the manner they have not received it, but they have received it. Because, my lord, paragraph 11, my lord, specifically says, make an amendment. My lord, kindly, my lord, takes the application once, paragraph 11.
Yes, I have taken note.
Which says, my lord, the way the payment has been made to them. Page 14 now. The last 4 lines they say about the checks. Again, this has been made over to the other legal entities with not regard to the defendant. And, my lord, with regard to, my lord's account close, just 5 or 6 lines, my lord, on top of that, my lord. My lord, no such documents of dishonored of all of which is mentioned in annexure has been relied upon by the plaintiff, except 1 checks being such and such, twice as page number such and such, but sought to be encashed by the petitioner, which was subsequently dishonored with the remark account close. Since 2018, the plaintiff, assuming that any cause of action did not take place against the defendant, further still the fact that there is no cause of action against the defendant or plaintiff. There is no, again, no reason, my lord, they say about why the account was closed, why the checks was not honored. There are no statements. Why they had issued those checks even, there is no statement with regard to the same, my lord. It's surprising note that defendant number 1 was asked to change name in checks. Pay's name differed. No checks even issued. Or kuch nahi hai na?
Yes, next.
This is attaching the draft inadvertently sent. And again, by that, and on the defendant number 1 has already filed this affidavit in issued page 20. Page 20. Two other affidavit. GA3, your service GA3.
You affirm copy of the same affidavit.
10th January 2025 is the हमने by that order we the one that we served by that.
Again, with how many evidence they have filed?
Let him come out from that.
This is an affidavit of yours only.
I just find the affirm copy with Lordship. So they can learn.
This is the one filed in January.
No, when affirm copy is changed with the draft copy again.
The order of
Changed. I don't know how many affidavits Mr. Dashgupta will file. It's also affirmed.
Filed with the leave of the court.
Which one you have filed now? Well, this was an affirm copy served upon us. We don't know which one has been.
10th of January.
Department give an enactment is not properly executed. Department give a report that the original affirm copy is not available in the record. Then Lordship gave me to reaffirm the same affidavit and
It should be the same.
I filed the same thing that's with the court and with me and also served upon your
The
copy.
pages should be same then. It should be the pages should be same and reaffirmed.
The same.
No,
the
no,
original I did not have.
10th January order.
If it's the same affidavit reaffirmed, then nothing should be changed in the affidavit. So the page should be same, the statement should be same.
Everything is same. Page number
The number also should be same.
number won't be same because I have annexed the order copy of Lord, my lord.
I am seeing the pleadings. I have not yet gone to the annexures.
Show it from no problem. Page numbers are defined because pagination are different.
I will always go to the picture. No, however, my lord, only one thing, my lord, they say that they made a statement, my lord, before the court that the originals were the letter which they issued, the original we have filed. Now, my lord, they withdraw from that and they now say the origin is lying with them. The original of the affidavit of page 247 is now lying with them. My lord, kindly, my lord, passes an order, my lord, they kindly, my lord, takes this. I don't know, my lord.
247.
The 247, the affidavit which I have shown, my lord, the 3rd April 2023 affidavit, which I have annexed to them, my lord, the petition, my lord. 247, my lord.
That is the letter.
That is the that's the affidavit, my lord. The letter is of, my lord, the page 120, my lord.
240 is the forwarding letter of the affidavit.
My lord, 247, my lord.
247.
Yes, my lord. Now that forwarding letter, my lord, they says that it's filed. Now, my lord, at page 22 in their opposition at paragraph 13, they make a statement that the original incorrect affidavit or the original affidavit dated April 3, 2023 was never filed with them. It's still lying with the advocate record of the defendant number 1.
Page?
Not page 22. Moreover, page should be, my lord, that paragraph should be, my lord, paragraph 13, my lord.
Of which? What?
Of the affidavit in opposition, my lord. There, my lord. Dated, my lord, GA3.
16 January.
Yes, my lord. 16 January, my lord. 27 June, my lord. No, my lord. My lord.
16 January 2025.
My lord, should be paragraph 13, my lord. Can you, my lord, take 15 January concept? My lord, should be, my lord, if that is the same affidavit is there, my lord. Can you, my lord, take page paragraph 13? My lord, the last 6 or 7 lines, my lord.
Reference to 34, 38.
Yes, no.
The reference to 38, 34, 38.
34 to 38, my lord. 34 to 38. Moreover, my lord, last 5 or 6 lines starting from paragraph 14, my lord. From moreover, the original incorrect affidavit, my lord.
Moreover.
Page 16 should be, my lord.
Page 16 now?
The new one. Page 16, middle part. Just the copied, my land has copied the content and pasted and
Where from we are getting?
middle part, moreover. Middle part of that.
Okay, moreover.
That is what my
My lord.
Moreover,
the original incorrect affidavit is still lying with the advocate record of the defendant number 1, which proves that said affidavit was never filed in the court. My lord, first they make a statement that has been filed in the court. Now, my lord, they're keeping the original. My lord, kindly calls for the original, my lord.
That's why the report was called for.
My lord, it is lying with them now. They say that it's lying with them. My lord, this affidavit been filed in GA1. Which, my lord, they say that is a wrong affidavit they have filed.
Correct.
My lord,
kindly
kindly
see the 10th January order.
Yes, my lord.
See the 10 January order. Counsel for the defendant submit that the defendants have affirmed the affidavit in opposition in connection with GA3 and also serve the copy to the learned
that's
counsel for the
GA3.
plaintiff, but the same is not on record. Correct. Accordingly, this court has called for the report from the registrar original side, full stop. On 20 December 2024, registrar original side has submitted report wherein it reveals that as per the ledger maintained by the department, it does not show affidavit in opposition is filed by the department.
Yes, but it's leading to GA3. What I am saying is that what they have stated is with regard to GA1, GA1, there are two affidavits filed, one affidavit where my whole statements, my whole plaint case has been affirmed by them, I want to say. Now that affidavit, that original affidavit, is lying with their office, is though they have made a statement that has been filed before court, however, they make a statement that it is lying before court, lying with them, kindly takes it is denied that affidavit dated April 3 was ever filed.
GA1 affidavit.
There are GA1 two affidavits. Kindly seeks the affirmation date. That's 19th April, my lord. I'm talking about affidavit dated 3rd April, my lord.
19th April.
Now, my lord, there is an affidavit dated 3rd April, which they say is lying with them. The original of the affidavit where my statements have been affirmed, my lord, all the statements which I have made, my lord, in the plaint, which they have said, which I have relied upon at page 247. Now they're coming up and saying, my lord, that this affidavit is not with the court. It is with them, my lord, lying with them. My lord, I'm seeking a request, my lord, kindly, my lord, directs them, my lord, to produce this original affidavit once, my lord.
Which is not on record. How?
My lord,
what you will rely?
With the leave of the leave I have granted, my lord, kindly, my lord, takes the order again, my lord, of Justice Mukherjee, my lord, at page 267, my lord. Without prejudice to the rights and contention of the plaintiff, if any respect of admission should be made in this first affidavit.
267.
Yes, my lord.
Yes. Correct.
But I have
been was now from the another affidavit of 19th April. The said affidavit filed in the court taken on record without prejudice to the right and contention of the petitioner, if any, in respect of any admission said to have been made in the first affidavit affirmed on 3rd April 2020, the plaintiff shall be at liberty to use an affidavit in reply to the affidavit in opposition affirmed on itna. That affidavit in reply filed.
Now, my lord, this 3rd April affidavit, my lord, contains, my lord, which page 247 am I next? My lord, contains all the admission. 247, my lord, kindly, my lord, takes again, 247.
This one you're telling?
Yes, my lord. That is what they are saying now, it's lying with them.
So this affidavit you rely upon?
Yes, my lord. And the original should be before court.
247 is the letter.
It starts and the affidavit is annexed thereafter.
Yes, it is continued 265.
265. The affirmation date, my lord, is, my lord, on, my lord, 3rd April 2023. 265, my lord.
So it was served to you?
It was served upon me. The original, though the letter says that the original has been filed before court. However, my lord, it is lying with them.
Yes.
My lord, kindly, my lord, directs the, my lord, the defendant's advocate, my lord, to produce this original affidavit, my lord. Let it be in the record, my lord, of this court, my lord.
Yes.
My lord, kindly, my lord, directs, my lord, the reason why I'm not require this original affidavit, my lord, later on, my lord, it should not come on with a plea and say that this original is not there or this original is, I don't know, I've not signed this
So
original
where is the
later
admission? Which portion you are relying upon?
on. 247, kindly,
247, yes.
Paragraph 5,
Paragraph
251,
5B. Paragraph
5B, C, D,
and
E.
What is the difference of the another affidavit of 24th April?
Well, it's completely different. This admission is not there.
They're the same.
24th April affidavit is completely different affidavit.
No, this is GA1.
GA1.
This is also GA1.
GA1.
Correct. So you are telling that this is changed by 19th April affidavit.
Lordship.
Correct.
Yes, my lord.
So what are this contention are not available in this?
No, my lord, it's not there in this. And this original of this affidavit, the GA1 affidavit, dated April 3, 2023 is lying with the advocate record of the defendant number 1. My lord, kindly calls for this original affidavit, my lord.
Okay.
My lord, so that, my lord, all records are there before court. My lord, that is required, my lord. My lord, because this affidavit is, we are relying upon this affidavit. If this original is not there before court, but later, my lord, I don't know, my lord, what plea, my lord, can be taken, my lord. My lord, that is the, my lord, request, my lord. And my lord, I'll continue some other time, my lord. I think those shouldn't have a problem.
Sense suffering for the plaintiff, sense suffering for the defendant.
It could be.
Counsel for the plaintiff has argued at length in connection with GA3 of 2023, wherein the plaintiff has prayed for judgment upon admission. Due to paucity of time, hearing could not be completed accordingly. Case is adjourned. Counsel for the plaintiff submit that the plaintiff, the defendant, by a letter dated, by a communication dated 4th April 2023, has forwarded an affidavit in opposition in connection with GA1 of 2022 in CS 182 of 2022. 182 of 2022. But subsequently,
At the date, my lord, so there will be otherwise dated, my lord.
which was affirmed,
Grateful.
which was affirmed by the defendant on
April 3, my lord.
On 3rd April 2023. And this copy of the said affidavit in opposition is disclosed by the plaintiff in GA3 of 2023, being page 247 to 265. Counsel for the plaintiff submitted that though the defendant in the communication dated 4th April 2023 has mentioned that affidavit in opposition filed on behalf of our client named above in connection with the above matter, but the original is not on record, and prayed for direction upon the department to place the original affidavit in opposition filed by the defendant in connection with GA1 of 2022 in CS 182 of 2022 affirmed on 3rd April 2023. Concerning the submission made by the counsel for the plaintiff, the department is directed.
The defendant, my lord, not the department, my lord.
There's been a change of advocate, my lord. It's with the erstwhile advocate.
Even if it's the erstwhile advocate, the affirmation has been done by the defendant number 1. This defendant number 1's contention, my lord, is there.
Is directed to
to
submit the report whether the defendant number
my lord 1, my lord.
Defendant number 1 has filed any affidavit in connection with GA1 of 2022 in CS 182 of 2022 affirmed on 3rd April 2023. Let the same report be filed before this court on the next date.
My lord, only one thing, my lord. They have, my lord, the defendant number 1 has stated, my lord, on oath, my lord, that they have the original. The department cannot have it.
Where?
My lord, page 16 or 22, my lord. My lord, I show, my lord. In GA, my lord, GA3, my lord, in their opposition, they have pleaded, my lord. I'm sorry, it was marked with red ink.
Last paragraph क्या बोला?
Red pencil.
Now, considering se pura card do. The counsel for the plaintiff has drawn the attention of this court to the statement made by the defendant in the affidavit in opposition in connection with GA1 of
GA3, my lord.
In connection with GA3 of 2023 affirmed on 27th of June 2023 at paragraph 13 page 22 stating that inverted comma moreover the original incorrect affidavit is still lying with the advocate on record of the defendant number 1 slash respondent number 1, which proves that affidavit was never filed in the court, full stop, not comma close. Subpara. In view of the above, the defendant number 1 is directed to produce the original copy of the affidavit affirmed on 3rd April 2023 in connection with GA1 of 2022 in CS 182 of 2022 on the next date fixed.
I'm so grateful, Manu.
Since the lordship is also putting a rejection against me, I am for the defendant number 1. But this affidavit says that it was lying with the affidavit categorically is lying with the earlier advocate.
Yeah.
So that what we can do, I have not, we represent the present advocates. We do not have a copy of this. When I first got briefed in the matter, I instruction of my on record. This affidavit, which was affirmed, I agree, and I admit, were never handed over to us at the time of change of. So lordship can record that submission, or I can come back with further instruction of my.
It is not upon the advocates, my lord. I am nothing against the advocates.
क्या बोला लास्ट में पैराग्राफ जो कंप्लीट हुआ था ना ये जो इनर्ट कॉमा क्लोज हुआ ना
Advocates don't have the copy of the record.
Defendant number 1 can answer.
ना इनमें हटा दो काट दो इनमें को काट दो Learned counsel for the learned counsel appearing for the defendant number 1 submits that initially some other advocate was representing the defendant number 1, and as such at present the learned counsel is not having the original copy of the affidavit which was affirmed on 3rd of April 2023
on record.
Full stop. In view of the above, considering the submission made by the counsel for the parties, comma, the defendant number 1 is directed to file an affidavit stating the fact whether the affidavit affirmed on 9th April 2023, 3rd April 2023 in GA1 of 2022 in connection with CS 182 of 2022 was filed before the court or not. If it is not filed, he clarify whether he will submit the said original affidavit before this court on the next date or not.
So grateful, my lord. Very grateful. Much obliged. Another date, next date.
Full stop. This is the matter on
any day. Any fixed time, my lord, if you get, my lord.
This is the matter on the commercial, non-commercial.
Commercial, my lord.
This is the matter on 18th March.
Not any fixed time, my lord, if you get.
Fix, then go April. 20 April at 3 p.m.
Have you come back? Not my opposition, my lord, may I will not.
Right.
When the copy, my lord, sir.
Yes, next.
Grateful, my lord.
Number 7 of the commercial.
Yes.
I had examined the witness. Only 1 or 2 questions, my lord. I'll just finish it today.
Grateful.
Lordship was very kind the other day to mark without the original, my lord, 1 set of documents. I just need a clarification there. Otherwise, the records are not looking, my lord, proper.
Chandan Jha.
Chandan Shah.
My lord, may I? Shown pages 23 to 40 of the judge's brief of documents. Where are the originals of these documents?
ये डॉक्यूमेंट्स की फोटोकॉपीज है हमारे फाइल में. We don't have the original documents in our file, लेकिन photocopies are there.
We do not have the original of these documents in our file, but we have the photocopies of the same.
What are you claiming? What is the plaintiff claiming in this suit?
We are claiming approx 76 lakhs from Balurghat Technologies through this letter.
And that should be all. I'll not rely on that document which Lordship was kind enough to mark as an exhibit. Without that, I'll justify, my Lord, that I am entitled to the relief. My Lord, there are a number of exhibits. If Lordship wants, I can prepare a very short note and I can give me 15 minutes. It would be done, my Lord.
Okay. Resume, Chief, resume. That's all.
That's all, my Lord.
उतर जाइए.
I can briefly indicate what is my claim about. My Lord, this is a suit for recovery of money. My Lord, I was supposed to, my Lord, send cargo to, my Lord, Hong Kong. Now, my Lord, the defendant was engaged as, my Lord, a cargo and logistics service provider. He was, my Lord, pursuant to the agreement which is recorded in an email, he was to provide me with 12 trailers. These trailers would have contained containers which would have contained the goods of the plaintiff to be sent from the manufacturing unit at Jharkhand and, my Lord, to the Kolkata port for ultimate, my Lord, loading in a vessel which would have, my Lord, gone to Hong Kong. This was, my Lord, the transaction. Out of 12, my Lord, gradually he said first 11, then 9. Ultimately, he could promise for only 5 trailers. Now, out of 5, there was a cut-off date within which the trailers should have reached the port. That was 10th of February, 2021. The trailers were required to reach on this date because the ship was to sail on 12th of February. Now, my Lord, out of the 5 trailers which he ultimately said he is going to provide, only 1 trailer reached just before 12th of February, that is just before the date when the ship was about to sail. We convinced, my Lord, the vessel owner, and, my Lord, we tried to, through our forwarding agent, we tried to, my Lord, withhold the ship for a while. We managed up to 15th of February. Within that date, my Lord, another 3 trailers comes. So out of 5, 4 trailers comes. The goods which were there in these 4 trailers that could have been, my Lord, loaded. The 5th trailer came beyond 15th of February when, my Lord, the ship had already sailed. So my claim is on 3 heads. My first head is, my Lord, the amount that I have paid to the forwarding agent. Second is, my Lord, on the 5th trailer, there was 125 metric ton of goods, which I had to ship separately. For that, I have a separate claim. And there is another third head of claim, 2 lakhs rupees, which I have incurred because they have given us defective, my Lord, trailers, which had breakdowns. I had to incur cost on that account. These are the 3 heads of claim on which, my Lord, I have framed this suit.
Okay.
This is, my Lord, sum and substance of the cause of action and my claim in this suit. I will just frame it in the form of a, my Lord, written note and, my Lord, assist your Lordship on the next day so that Lordship can reserve it for judgment.
So appearing for the plaintiff. Plaintiff witness is present. Examination chief is resumed and concluded. Counsel for the concluded. Fully counsel for the plaintiff submit that he will not adduce any further evidence. Full stop. Evidence on the side of the plaintiff is closed. Full stop. Let the matter appear. 345 कोई है? नहीं है.
Commercial.
March at 3:45. 19 March 3:45 for argument. The plaintiff is directed to come with the written notes of argument.
Very grateful, my Lord.
Next.
Number 17.
No, I'm appearing for the defendant, my Lord. I'm being led by Mr. Gupta, my Lord.
Yes.
My Lord, Mr. Gupta was yesterday indicated, my Lord.
Yes.
The defenses, my Lord, with regard to the goods which were defective, my Lord, which we had to replace, my Lord, to Pranjal Paul. My Lord, there was another invoice, my Lord, in respect of which the goods supplied were defective. My Lord, will kindly find the list of defective goods in page 11 of our AO, my Lord.
Item number
17, my Lord.
Yes. Page number?
Page 11 of the affidavit in opposition, my Lord.
Yes.
My Lords, kindly, my Lord.
This fixed matters are most dangerous. If my matter is the next one. when it will be over, that's the one. But may I start with the point which your lord, which possibly was troubling your lordship yesterday, my lord, which is, my lord, my affidavit in opposition and annexure R1.
Yes.
Where, my lord, your lordship had pointed out at page 27 that this invoice number 275 has been shown. This, my lord, this your lordship would kindly see. This is, my lord, firstly, not a payment made. This is a debit entry recording the sale.
Correct.
So, my lord, that way, my lord, they have recorded all the invoices. But I am saying, and the defendant has stated on oath that these invoices and these goods have not been delivered to me. So, my lord, this particular invoice, your lordship would find is recorded in their ledger as a debit entry, only showing sales. But the payments which have been made, that is the right-hand side column where the credit entries are made. Your lordship would find that, my lord, payment in respect of this has not been made by me. I say that this payment of 7,43,000, which is the last entry on this page, is perhaps, my lord, payment in respect of this invoice made by Johor Shur Chaudhary, because I have not made any payment of this invoice. So, my lord, this entry is the plaintiff's unilateral entry in their ledger. That way, my lord, all the invoices they have, my lord, included, four or five of which do not concern me. My lord, page 66, kindly, my lord, reads this along with page 66 of the opposition, where I had also indicated this fact. Though I had taken your lordship to this email yesterday,
Yes.
and where I had said that certain other entries have been shown. Kindly see this. 17th March 2016. Please check the ledger details, as because some permit you have shown in favor of me, but actually some materials handed over to other party. So, my lord, this we had already pointed out.
Yes.
Apart from the other, my lord, issues which have been there. Now, if my lord kindly, my lord, takes a look, looks at the pleadings in the affidavit in opposition once, just to show, my lord, the how we have dealt with. Kindly sees page 5. But firstly, paragraph 6 is where all the sub paragraphs are, which I had been placing yesterday and the day before also. My lord, we have gone invoice wise. So, my lord, paragraph 6A, my lord, we have dealt with these two invoices, 022 and, my lord,
64.
64, which I have already said that we have not received. But these go on till paragraph D. Paragraph C. Then D is, my lord, invoice number 77 and 275. This, my lord, I had placed yesterday, and, my lord, 275 I had just now submitted. This also I have not received. Now, my lord, kindly sees paragraph G. This is in respect of, my lord, that Johor Shur Chaudhary. That is paragraph G. Then, my lord, paragraph H. But H is, my lord, page 261 of this is the third volume, if my lord is pleased to keep that side by side. My lord. Third volume is that their table which they had given of all the invoices, my lord,
Yes.
from which I was placing. So, my lord, this paragraph H deals with, my lord, payments which have been received by the plaintiff from Royal Engineering. And, my lord, I shall show how. In page 261, the plaintiff had given, my lord, a schedule of payments received from me. 261.
Yes.
কোনগুলো নিয়ে এই তিনটে তো পার্টিকুলার এই তিনটে তো লাস্ট তিনটে নয় তো
লাস্ট তিনটে নয়
যে তিনটে আমরা বলেছি
No,
so this my learned friend is admitting that this is a clerical mistake in their accounts.
yes, but regarding that,
Three entries your lordship would kindly take a note. Yes,
Where is that?
page 261,
Yes. 51,
third volume of the Malad application.
But may I only once, Malad, to interrupt?
Yeah, that last three,
No, not the last three. That is what I am saying.
because last three he has received from the third party. He has admitted. Kindly count 261.
Yes, I'm there.
Last three, 10 lakhs, 10 lakhs, and 10 lakhs.
This is incorrect.
10 lakh, 10 lakhs, and 20 lakhs.
This is incorrect. These payments I have made. The mistakes are three other entries.
He has admitted on the when he has.
I know. Both Mr. Agarwal and I have checked the video the last day submissions. That is why I wanted to clarify. These payments I have made, and for this reason, I am carrying the bank statements. I should show that. But kindly takes a note of three entries in this page which I have not made. Not these last three. The three entries are 8 June 2015, 3.5 lakhs.
8 June 2015, yes.
3.5 lakhs.
Yes.
Then 6th October 2015, 5 lakhs.
Yes.
And Malad, 11th December 2015, 5 lakhs.
This not paid.
This is not paid by me. And Malad, to support that and to contradict my learned friend's submissions while he was making his arguments with regard to the payments in this page, but I have got the bank statements for the relevant period.
So this with regard to the other three, which they are, this has been paid by you.
Yes, last three have been paid by me. The other three have not been paid.
Those are larger amounts.
No, that's why I'm getting the bank statements.
But it may as well be our fault, Malad.
I'll show from that.
I was instructed there are three payments.
I understand,
well,
but
right?
since that was since despite in the application they have said
He is Gupta.
he is that.
I am Das Gupta. I am his servant.
Yes.
Well, since this fund was not taken on affidavit, so we have got this this bank statement.
Bank statement of whom? Achha.
My bank account. But firstly, kindly sees 8 June 2015 and kindly sees the entries around that period. Kindly sees kindly turns to the fourth page. But your lordship would find the first entry is 18/5/2015.
Yes.
Kindly sees the June entries. It starts.
Yes.
It starts from 4th June. Then going on to the next page, the last entry in June is 26th of June 2015. But your lordship will not find this 3,50,000 entry. So I have not made this payment.
3,50,000.
Yes, it's not. Your lordship will not find that
8
payment.
June.
8 June. Kindly see there are other entries on 8 June, but this 3,50,000 is not there. Similarly, so far as this 5 lakh is concerned, that was 6th of October 2015. If my lord kindly skips 3 or 4 pages, your lordship would find the page from where the first entry is 29th of September 2015.
Twenty-ninth of September
2015.
2015, yes.
And your lordship would find October entries towards the middle of that page.
6 October.
Yes. 1st October is a payment made by me to the plaintiff.
Yes.
That is 3 lakhs. That is also reflected in his statement. 1st October 3 lakhs is reflected. Your lordship has seen.
Yes.
Then my lord kindly turns to the next page. 4,75,000 made to the payment. That is also reflected at page 261.
Yes.
And also 2,25,000.
Yes.
But my lord, this 5 lakhs, which is shown to have been made on 6th of October, is not there. Your lordship will not find any entry on the 6th of October. But the other payments are reflected.
Yes.
Now, my lord, this leaves us with the last one, This is 11th of December 2015.
Yes.
My lord, kindly takes a look at, my lord, the last 2 pages, last 3 pages, my lord, third last page. My lord, your lordship would find, my lord, one payment has been indicated here. 21st November 2015. Your lordship would find 10 lakh.
Yes.
My lord, that has been reflected at page 261 as on 20th of November.
20 November, 10 lakh.
10 lakhs. Then, my lord, your lordship would not find the entry of, my lord, 5 lakhs on 11th of December 2015 from the other, my lord, I have given the entire bank statement for that period. Your lordship would not find that entry.
Yes.
Then the next payment which I have made is of 4 lakhs, which your lordship would find in the last page. That is for 19th of December 2015.
Yes.
That is also reflected in page 261. So the entry in between of 5 lakhs is not paid by me. So this shows that the others, he had received payment from others, but is showing as I have made payment. So that is why I have got this bank statement for this period.
Yes.
So, my lord, this possibly, my lord, humbly takes care of, my lord, the contentions in subparagraphs, my lord, H.
Yes.
So, my lord, summing up in paragraphs J and K, I say that, my lord, out of 198, 74, 184, which the plaintiff has said to have delivered to me, my lord, this takes care of up to, my lord, 165, 56, 988. That is paragraph K, because the other amount 16,72,000 and 16,44,000 I am not liable to pay for 2 different reasons which I have shown. Then, my lord, comes the issue of, my lord, 1,33,50 which I admittedly receive. I admittedly receive 133.50 worth of goods. Out of this, then paragraph, my lord, N O, it goes from N. This is the Pranjal issue which I had been placing yesterday. I had placed yesterday. This goes up to, my lord, paragraph X. In fact, Y.
Yes.
But where I had said that I had made this replacements. Now it fell from your lordship. What did you do with the goods? So part of the goods was, it's a road work, so it was utilized. But kindly see paragraph X at page 10.
Yes.
Thereafter, the plaintiff caused such balance goods of the said consignment, being 12 drums of cold mix and 41 drums of emulsion, to be lifted from the defendant's office. So this was the unutilized goods which were lying, which they had, you know, taken away. But the balance was utilized. Now, we'll kindly see paragraph Z. There was a further consignment delivered to the defendant by the plaintiff of the said goods under invoice number such and such 232, where 100 numbers of cold mix were given. Well, this was the inferior goods, which we had referred to. This is R6. Your lordship would find that at page 40. This is 100 drums of cold mix, page 40.
Yes.
And all the other documents with that. Now, on the issue of replacing inferior goods, if I may just read on a couple of more paragraphs, with my lord's kind indulgence, your lordship would say, see that in paragraph AA, I had indicated which all invoices covered the defective goods. I've given the invoice numbers and the aggregate of the invoices 22,96,224. But I had stated in paragraph BB that I had replaced goods worth 12,20,205 to Pranjal, which was found to be defective, and I had replaced with goods of Bitchem brand, which is a different brand, of 13 crore 14 lakhs. 13 lakhs, I'm sorry, 13 lakh 14,000. That is my paragraph CC. In respect of this, kindly takes a look at annexure R7. which is at page 44 onwards.
Yes.
Page 44, if my lord is pleased to turn to, my lord will find Bitchem selling to the defendant the same goods, my lord, Bitchem cold mix.
Mascot Petroleum, Roy Associates.
Yes, Roy Associates is the defendant. Kindly sees the description of the good, Bitchem cold mix.
Cold mix.
Yes, and also sees the next page, page 45, it's emulsion. These are the two goods, my lord, emulsion and cold mix, which were replaced. Kindly turns to my lord, page 45, my lord will find it's emulsion.
Yes.
And also page 46, my lord will find both cold mix, emulsion, and it goes on to my lord, page 47.
Yes.
So, my lord, these are the replacements which I had, my lord, ordered from a different company and delivered to Pranjal Pal. Just for the completeness of my arguments, and may I only show your lordship, my lord, the invoices by which the challans by which I had delivered this to my lord Pranjal Pal, though I had shown yesterday, page 31 and 32.
Yes.
Cold mix, your lordship would see cold mix make Bitchem, emulsion also make Bitchem.
48.
Yes, both pages, my lord, different numbers, quantities. So, my lord, this possibly, my lord,
That is covered in 31, na?
yes, 31 and
Cold mix
32.
is the 48 numbers
Yes,
and
yes.
emulsion is the 18 numbers.
Yes, and also 32. Cold mix is 40 and emulsion is 37. 2 pages,
Yes.
2 challans.
Yes.
So, my lord, I had replaced the goods. Now, my lord, kindly takes a look at paragraph DD, where, my lord, I had stated that apart from these 3 consignments aggregating to rupees 2296, which I had indicated in that small table, my lord, the defendant on instructions of the plaintiff caused 61 drums of cold mix worth 4,85,000 to be delivered to a client of the plaintiff, Shopon Chandra De. Copy of the challan evidencing receipt of the seed goods by Shopon Chandra De is annexed as marked R8. And R8, your lordship would find at, my lord, page 48.
Yes.
My lord, page 48 is where, my lord, I had delivered it to Shopon Chandra De on the instructions of the plaintiff. This Shopon Chandra De had, my lord, made payment to the plaintiff. And I have pleaded that copy of the challan that I have said, then from the ledger sent to the defendant by the plaintiff by the email dated 4th March 2017, the defendant has been able to ascertain that the plaintiff has received rupees 2,08,000 on 7 June 2016 from the said Shopon Chandra De. My lord, this your lordship would find, my lord, at page 27 of my affidavit in opposition, where, my lord, just above Johar Shur Chaudhary is Shopon Chandra De. So, my lord, this payment he has received of 2 lakh.
Page?
Page 27 of my affidavit in opposition, of the same affidavit.
Yes.
My lord, kindly sees the last part 1 entry, Shopon Chandra De, 7 June 2016, 2,08,000. Just above Johar Shur Chaudhary.
Yes.
Now, my lord, that really leaves us with paragraph E, where I say that after giving all these deductions from the goods I have received on different counts, my lord, there was goods worth 6 lakh, which was left. Those were unfit for use and has been picked up by the plaintiff's representative at Agartala. That is my pleading in paragraph EE. Then my pleading in paragraph FF is that the plaintiff has issued credit notes in my favor of 4,13,000. Well, those I have annexed at page 49 onwards of my opposition. Annexure R9 is page 49 onwards. And this fact has been admitted by the plaintiff in their application as well. Now, they had admitted this at page 261. 260, I'm sorry. 260. Third volume. Page 260, where they have indicated the credit notes.
Credit notes.
Yes. So, my lord, this worth 4,13,000 odd was the credit notes which was given.
Yes.
Now, my lord, paragraph GG is where I had stated that this 5 lakh goods which was received by one of the clients of the plaintiff has been made directly by him, directly to the plaintiff. That amount is this amount at page 261 of 11th of December 2015, the 5 lakhs. This 5 lakhs is this amount which I have pleaded in paragraph GG. But my client directly paid to the plaintiff. I have given the exact date, my lord, of the payment.
Yes.
In paragraph GG and HH, I have indicated this.
Yes.
Now, my lord, interestingly, in paragraph II, I had pointed out the dichotomy in the case made out by the plaintiff. In one place, the plaintiff has said that an amount of 38 lakhs is due and payable on account of principal. That, my lord, will find in page 27 of the affidavit in opposition, that ledger. Kindly sees the entry just above the closing balance. It's 38 lakhs 9,130 at page 27.
Yes.
Of the,
Yes.
this is the last document which they had given me, the ledger. In the application, or in the plaint rather, they had claimed a principal amount of around 47 lakhs to be due and paid. That, my lord, will find at, my lord, page 6, paragraph 11, really going on to page 7.
Of the application?
Of the application, first volume.
Page 6?
Page 6, paragraph 11, at page 7, my lord.
After giving due credit to the Samagri 1 crore 51, this is the petition.
Still liable to pay rupees 4760. And the amounts have been given here.
4750, yes.
So, my lord, in the ledger which they have given by way of the email, their claim is 38. But in the application, they are saying it's 4760, or in the suit, in the plaint. But I have covered all the other issues barring 2.
Yes.
But one is the interpolation of the checks, and the other is the limitation. Because I would submit that the claims are wholly barred by limitation. And I would show that. Firstly, I wanted to take the bull by its horns and say why it is not maintainable evil on merits, so that your lordship would not think that I am otherwise trying to go out with only the limitation point. But so I kept it for the last. I'll try and satisfy your lordship on that as well.
Okay. When the advocate starts the technicality, then it's find that there.
That is why if I have a proper defense on merits, my lord, then my lord.
Sense suffering for the plaintiff, sense suffering for the defendant. Counsel for the defendant had argued at length in connection with GA2 of 2021, but due to paucity of time, hearing could not be completed. According case adjourned, let the matter appear on. Let it be in the list, we'll see to that.
The only thing is Friday is that special bench where the reference from 106.
That is there.
That is fixed on Friday. So, let it be in the list.
Not, I am not fixing on Friday. Let it come on 10th of.
Whenever.
10th March.
Yes. But in that matter, Mr. Anindya Mitra has been appointed as the amicus.
Good. No, it matters to be settled.
It has to be settled.
Otherwise, because now the commercial code,
yes,
all the so there are several things to be settled now.
Yes.
Because some high courts are passing some orders, some high courts. So if it is settled once, then it will be good in future.
Right. Great.